A very good morning and welcome to the 10th meeting of the Criminal Justice Committee. We have no apologies this morning, and agenda item 1 today is the continued consideration of the Victims, Witnesses and Justice Reform Scotland Bill at stage 2. I would ask members to refer to their copy of the bill and to the marshalled list of amendments and groupings for this item. So I welcome Angela Constance, Cabinet Secretary for Justice and Home Affairs, and her officials to the meeting. And I remind the officials that they are here to assist the Cabinet Secretary during the Stage 2 debate. They're not permitted to participate in the debate, and for this reason, members should not direct questions to them. And I also welcome other members of the Parliament to the meeting who are here to speak to their amendments. I welcome Jamie Green, Pam Gosel and Maggie Chapman. So I will stop at various points, you'll be glad to hear this morning, to allow short breaks in the proceedings. So we now begin our consideration of amendments. So I call Amendment 85 in the name of Pam Gosel, grouped with Amendments 241 and 242. Pam Gosel to move Amendment 85 and speak to all amendments in the group.
Thank you, Convener. Good morning, Committee, and good morning, Cabinet Secretary, and good morning, officials. I will be speaking on my amendment, all amendments in this group. My amendment number 85 makes the introduction of non-harassment orders mandatory in the sentencing of sexual offences. Having spoken to survivors of sexual crimes and domestic abuse, it is clear that non-harassment orders are vital for their safety. Survivors might feel safe when their abusers are in prison. However, what happens when they are released? Amelia Price, who it is my understanding has contacted the Cabinet Secretary for Justice and the Minister for Victims and Community Safety, was raped and assaulted by her ex-partner. He is currently serving time in prison, but is due to be released from prison later this year. The judge in the case was required under law to consider a non-harassment order. However, Amelia was told he did not impose one because her abuser had not contacted her since she reported him and she no longer lived in Scotland. Therefore, my amendment would ensure that these orders are issued automatically, and I move it in my name. Amendment 241, in the name of my colleague Sharon Dowie, extends these protections to cases of domestic abuse, which is also something extremely important, as domestic abuse has been an epidemic in Scotland with cases rising. An FOI has shown that in financial year 2023 to 2024, non-harassment orders were applied at sentencing in just 38% of domestic abuse cases. That is almost two-thirds survivors living in fear that their abusers could contact them. That is why I urge members to support this amendment. Amendment 242, in the name of Maggie Chapman, also extends the criteria to which non-harassment orders are made in sexual crimes, which I would also urge colleagues to support. Thank you.
Very much. So Sharon Dowie to speak to Amendment 241 and other amendments in the group.
Thank you, Convener. My Amendment 241 would protect victims of domestic abuse by requiring anyone who is convicted of a domestic abuse offence to be subject to a non-harassment order. This would protect victims of domestic abuse and safeguard victims. I know that the Government has concerns about the impact this would have on the discretion of courts to make sentencing decisions in individual cases, and I am grateful to the Cabinet Secretary for offering to meet with me to discuss how we can improve protections for victims in this regard ahead of Stage 3, and as a result I will not be pushing this amendment today. Thank you.
Thank you very much. So I call Maggie Chapman to speak to Amendment 242 and other amendments in the group.
Thank you very much, Convener, and my thanks to the committee for their work on this, and thanks to the Cabinet Secretary for the many conversations we've had about this bill over several months. I'm particularly grateful to all the organisations and individuals who've taken the time to speak to me about the issue of non-harassment orders. I'm particularly grateful to Amelia Price for her dedication to see change. And I remind colleagues of my register of interests. Prior to being elected, I worked for a rape crisis centre. If I can briefly address the two other amendments in this group before I come to my own. Firstly, amendment number 85, in the name of Pam Gosal, does not cover all Schedule 3 offences, whereas mine does. It also applies where the perpetrator is known to the survivor. And I appreciate that, as we know, most sexual offences are perpetrated by family members or those known to the survivor. But it does seem to me a little bit problematic that Pam Gosal's amendment doesn't include situations where the perpetrator is a stranger to the survivor. And that is what my amendment does seek to address. In terms of Sharon Dowie's amendment 241, hers is in relation to domestic abuse cases only, as she and Pam Gosal have outlined. So both hers and mine, I think, are complementary, and I would encourage members to support Sharon Dowie's amendment. On to my amendment. The need for this has been recognised for a long time, as Pam Gosal has introduced too. In 2017, at stage 2 of the then Domestic Abuse Bill, the Criminal Justice Committee heard from Linda Fabiani, who proposed an amendment calling for mandatory non-harassment orders. This was supported by John Finney and Scottish Women's Aid. Linda Fabiani had heard what she described as compelling evidence and quoted a survivor, and I quote, "A criminal conviction was of absolutely no use to me as a victim, since that conviction on its own contained no provision to protect me from further abuse." End quote. Amelia Price has also been campaigning on this issue for a long time, and Pam Gosal has already outlined her case. It's quite stark, I think, in Amelia Price's case that the grounds for not granting a non-harassment order were that her perpetrator had not tried to contact her, but that was when he had conditions that restricted his contact. Once those come to an end, those conditions would lapse, and therefore there would be no restrictions on whether or not he could contact her. So to use that as evidence for not granting a non-harassment order seems perverse, absolutely and utterly perverse. We also know from Amelia that there are other risk factors that weren't taken into account in the assessment of whether a non-harassment order should be granted. And I think we need to ensure that we listen to survivors. They understand the risks that they face, and we need to ensure that we listen to them. There is currently no provision for a survivor to challenge the decision not to grant a non-harassment order, other than to take civil action. And we all know the cost, the time, the trauma that will entail. We should not put survivors through that. We also need to recognise that survivors can evaluate the risks of harassment they face and should be doing what we can to ensure they feel protected and supported. They are much more likely to come forward and report offences in the first place if they know they will be protected after the fact. That is why I urge colleagues around the table to support my amendment. Thank you.
Okay, thank you very much. So I'll now open it up to other members, and I'll bring in Fulton McGregor.
Thanks, Convener, and good morning to colleagues and the Cabinet Secretary and our team. I'll be very brief, Convener. I just also want to take the opportunity to put on record my thanks to Amelia Price, as others have mentioned, who has also been in touch with myself, and we've had some correspondence back and forward. And I want to thank her for her bravery in bringing her own situation forward at this stage of the bill. I do believe that the three amendments have merit, but as Maggie Chapman's went on to outline already, Pam Gosal's amendment does not cover where the perpetrator is a stranger, and that does seem to be an issue I think would need to be ironed out. As Sharon Dowie's already said, I know that the government will cite concerns around how these amendments might impact on court decision making. I think that's something that we need to be completely aware of. So I wonder if, and I've not had a chance to speak to members before the meet today to ask this, but I wonder if the Cabinet Secretary and those moving the amendments today have any plans to meet ahead of stage 3 to perhaps iron out the difficulties and try and find something that meets the objectives and aims of the amendments and allows them not to push that today. But that's perhaps something the Cabinet Secretary and Pam and summing up can address. Thanks, Convener.
Thank
Thank you. It was just a quick contribution to say that similarly, I'm very sympathetic to the subject matter that Pam Gossel, Sharon Dowie and Maggie Chapman have brought to the committee, which I'm very grateful, because I think I'm right in saying that the Parliament and, in fact, a former Justice Committee first addressed the question of the fact that it's very costly to get a non-harassment order in the civil courts, and that we needed to do more to make sure that courts could apply them of their own volition where that was necessary. But we haven't made the progress that we should have made, and many women who don't even qualify for legal aid because there are some benefits which actually are contributory benefits who are losing out. So the principle is definitely right here, that the court can apply non-harassment orders in cases where it's quite clear, maybe domestic abuse cases or sexual offences cases. So I'll hear what the Minister has to say before deciding on how to vote on it, but I just wanted the members to know that I really appreciate them bringing to the committee and very sympathetic to the subject matter. Thank you.
Thank you very much. And I'll bring in Katie Clark.
Thank you. And I'm also very grateful to members for bringing these issues to the committee and for the work they've done. It would be helpful to have a better understanding of the differences between the different approaches. I'm more sympathetic to Maggie Chapman's approach, where it's not mandatory as such, in that there are situations, for example, where the victim doesn't want a non-harassment order for some reason, and there are reasons why some victims would not want a non-harassment order, and that is included in her proposal. So I'm more sympathetic to that approach. But I noticed that she was supporting Sharon Dowie's amendment, and it would be helpful to know, perhaps in summing up, whether Sharon Dowie's amendment would also mean that there would be situations where the court wouldn't apply a non-harassment order because of the specific circumstances of the case, because we would always want the court to have discretion, given they would be fully aware of all of the facts. But I think the point made about the low usage of non-harassment orders at the moment is a powerful one, and this attempt to try and shift the onus. So there's a presumption that in most situations it might be appropriate, particularly where there's been bail conditions, that the offender shouldn't approach the victim. That would seem to be a situation where it would be appropriate to continue an order of the court so that there isn't contact, as long as there is the provision that representations can be made where that's not appropriate. So I'm sympathetic to what the members are trying to do, but obviously we need to get the detail right, and I look forward to hearing what the Cabinet Secretary has to say.
Okay, thank you very much. Okay, so I'll bring in the Cabinet Secretary.
Thank you very much, Convener, and can I also add my thanks to members for their diligence in this area, and also put on record my thanks to the many survivors that I have met on this and other matters. Convener, this group of amendments seeks to achieve something that we are all committed to, namely ensuring that victims are fully supported by the justice system and that appropriate sentencing options are available and used by the independent court to help protect victims. I cannot support these amendments as drafted, but I have written to Pam Gossel, Maggie Chapman and Sharon Dowie to indicate that I'm very sympathetic to what are clearly well-intentioned amendments, and to suggest that we work together ahead of stage 3 to deliver the underlying policy aim of improving protection for victims. Convener, the role of our independent courts in considering the need for protective measures for victims is a critical part of the criminal justice system, and this is especially relevant in cases involving sexual offending. The issue of mandatory non-harassment orders, or NHOs, was debated during the passage of the Domestic Abuse Scotland Act 2018. And it was argued at that time that mandatory NHOs in all domestic abuse cases were not appropriate due to the fact that the Crown prosecute a broad range of domestic abuse cases, and removing all discretion from the court may result in NHOs being made when they were not appropriate given the circumstances. During these debates, there was a concern that mandating the use of NHOs in all cases may have risked undermining the credibility of NHOs if it required the court to make them in cases where there was no reason to consider it necessary to do so. However, I very much do acknowledge that a great number of cases will require the protection of NHOs, and the court has power to do this under the existing law. But not necessarily all cases will require imposition, and allowing the court to make that judgment is part of their independent sentencing duty. And just for information, Convener, in terms of the application of non-harassment orders for DASA convictions under the 2018 Act, the figures for 2024-25 thus far show that 82% of cases have an NHO applied to them. The figure that Ms Gossel quoted, the 38% figure, is for any offence with a domestic abuse aggravation, and that has increased from 11% in 2019-20. Convener, if I can turn to Ms Gossel's Amendment 85, is in its current form, it's unclear how a court would go about deciding what conditions should be included in an NHO in cases where the court's view was that an NHO was not required to protect the victim, but the law nonetheless obliges them to make one. It's also worth noting that there are other protective orders which a court can make in respect of some of the offences listed in this amendment, such as a human trafficking prevention order, a sexual harm prevention order, or a female genital mutilation prevention order, which may be a better way of the courts dealing with the risk posed by the offender than a non-harassment order, rather than there being a mandatory position. Convener, I also want to touch on a significant risk that may arise through requiring a victim to give consent for an NHO, as there may be unintended consequences. Scottish Women's Aid and Rape Crisis Scotland have raised this issue in our engagement with them. While I understand why this provision is here in the context of a mandatory requirement to make an NHO, it does mean that there is a risk that an offender may seek to pressure the victim not to agree to the making of a non-harassment order, especially in cases involving coercive control, and that is not something that any of us would want to see. So whilst for these reasons I do not support Amendment 85 in its present form, I do consider that there is a strong case for ensuring that victims of offences of the kind covered by Amendment 85 are afforded the same protections that currently exist for victims of domestic abuse offences. Therefore, I would urge Ms Gossel to work with me on a suitable amendment ahead of Stage 3. These same arguments apply to Sharon Dowie's Amendment 241, which seeks to make it mandatory for the court to impose an NHO in all domestic abuse cases. As I have said, the courts are already required to make an NHO in any domestic abuse case unless the court concludes that there is no need for the victim to be protected in this way. This amendment would require the court to make an NHO, notwithstanding that they have concluded that it's not required to protect a victim. In such cases, it's not clear what restrictions they would or could make in an order. There are no standard conditions that must be included in an NHO. However, typically, an NHO could include conditions like not contacting or approaching the person protected by the order, or not coming within a certain distance of where they live or work. But it's not clear these would be applicable in cases where the court does not consider protective measures are needed, yet an NHO must be imposed. Maggie Chapman's Amendment 242 seeks to make the imposition of an NHO mandatory in any sexual offence cases where the victim does not take steps to indicate it should not be made. Therefore, if the victim does not offer a view, then the NHO has to be made. In circumstances where the victim indicates an NHO should not be made, the court can still make an NHO if the court concludes that the degree of risk posed by the perpetrator to the victim is such that the making of the order is necessary. This second element is, of course, exactly how the current law operates, where the court has discretion to make an NHO even where the victim does not wish them to do so. Convener, I very much acknowledge this approach may seek to address the concern I have highlighted with Amendment 85, whereby it could encourage perpetrators to pressure a victim into not agreeing to make an NHO. However, by removing discretion from the courts in individual cases, I have the same concerns about how the court go about making an NHO in a case where they do not consider it actually necessary to do so, either because they do not consider that the perpetrator poses a risk of harm to the victim, or because they consider that an alternative protective order may be more appropriate to manage risks posed by the offender. And perhaps, some examples of when a court may decide that an NHO is not applicable, particularly in relation to sexual offences. That could be where it's an online offence, where the victim is not known, but by the making of an order, the victim would therefore be known to the perpetrator. Amendment 242 also provides the victim with a right to apply to the court to vary or revoke a non-harassment order. Under the current law, it is only the prosecutor and the person against whom the court has been made as the parties to the original criminal proceedings who have this right. However, again, while I do not support Amendment 242 in its current form, I have sympathy for what part of it seeks to achieve, and I am confident that Ms Chapman and I can work together ahead of Stage 3 to consider further whether it would be appropriate to provide victims with a right to make an application to the court to vary or revoke an NHO without having to go via the prosecutor. Therefore, I would urge Ms Gossel, Ms Dowie and Ms Chapman to withdraw Amendments 85, 241 and 242 in favour of working together on amendments so we can seek agreement on this for Stage 3.
Okay, thank you very much, Cabinet Secretary. So, Pam Gossel to wind up and press or withdraw Amendment 85.
Thank you, Convener. In line with what the Cabinet Secretary said, I'm happy to work with the Cabinet Secretary before Stage 3, so I won't be pressing, Convener.
Okay, thank you very much. So the members indicated that they wish to withdraw the amendment. Does the committee have any objection? No? Okay, thank you very much. So I call Amendment 88 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie, to move or not move?
Not moved.
Okay, thank you very much. So we now move on to the group entitled Special Measures Criminal Cases. And I call Amendment 89 in the name of Sharon Dowie, grouped with Amendments 216 and 217. Sharon Dowie to move Amendment 89 and speak to all amendments in the group.
Thank you. Amendment 89 would ensure that witnesses are given information on the special measures available to them in all cases. It would also mean that where victims of certain sexual offences request to give their evidence in a particular way, then that must be how they give their evidence. For all other vulnerable witnesses, the approach would remain as it is at present. This would ensure that victims and witnesses are listened to and would improve their experience in dealing with the justice system at what is a deeply distressing and traumatising time for them. Victim Support Scotland has made the point to the committee that there is a need to ensure that victims have a choice in how they provide evidence, and I hope that the Government will reflect on the need to do more to ensure that victims do not feel like witnesses in their own cases. And I move the amendment.
Okay, thank you very much indeed. So, Cabinet Secretary to speak to Amendment 216 and other amendments in the group.
Thank you, Convener. I would like to start with Ms Dowie's Amendment 89. At Stage 1, the committee heard very moving testimony from victims and survivors on their experiences of the criminal justice system, sharing that they felt that they did not have enough choice in how they gave their evidence. And whilst I totally support the principle of addressing those concerns, I cannot support the amendment due to its approach and the impact of how it would practically work within the existing complex legislative framework that provides for special measures. The amendment would give all deemed vulnerable witnesses across summary and solemn courts an entitlement to non-standard special measures. This is a very significant change that would create significant extra costs, have huge implications for resourcing and crucially strip the courts of an important function in balancing rights. To illustrate this, an example of non-standard special measures is evidence by Commissioner, which allows a witness to pre-record their evidence in advance of a trial in a more trauma-informed environment. Work is already underway through existing legislation to carefully manage the rollout of access to pre-recorded evidence, in part to avoid overwhelming the system, but also to ensure that we are appropriately prioritising pre-recorded evidence for children in the most serious cases. This amendment would massively disrupt this work and place significant additional demands on the criminal justice system. This amendment would also remove the court's ability when considering special measures to balance the rights of all parties and ensure fairness for the accused in accordance with Article 6 of the European Convention on Human Rights. In addition, the amendment places an obligation on a party citing a vulnerable witness to provide them with unspecified information about special measures. Most vulnerable witnesses are cited by the Crown Office and Procurator Fiscal Service and therefore already have a number of existing rights to information, including in relation to special measures. So I do not think that another statutory obligation is necessary or meaningful. The amendment also puts this obligation on courts, requiring them to provide vulnerable witnesses with information after a vulnerable witness notice or application has been lodged. However, courts do not routinely have contact with witnesses at this stage. So again, the amendment would be potentially far-reaching, resource-intensive and significant, causing duplication, inefficiencies and delay across cases. The amendment also duplicates existing obligations to seek the views of vulnerable witnesses on special measures. The party citing a vulnerable witness is already under an obligation to seek the views of a witness on what special measure or measures they would like to use when giving evidence. For these reasons, I do not support the amendment. However, I understand what the member is trying to achieve, and I hope she and the rest of the committee will be reassured and supportive of the amendments in my name in Group 27 that will address the committee's views in the Stage 1 report that the way the bill provided for pre-recorded evidence in the Sexual Offences Court failed to recognise the importance of choice for the complainants. My amendments will provide more control to complainants in a targeted manner by removing the discretion of the court to require them to use pre-recorded evidence where that is not what they want. I believe that is the right way to address the concerns raised at Stage 1, which were not about a perceived lack of entitlement to special measures, but about where a complainer has that entitlement, making sure that they are not required to use those special measures if that is not what they want to do. Convener, if I can now turn to Amendment 216 in my name, which creates a new non-standard special measure of admitting the record of a prior examination as a vulnerable witness's entire evidence. Currently, although some witnesses can pre-record their evidence ahead of trial, that evidence cannot be reused as that witness's whole evidence in any subsequent separate criminal proceedings. An example of when this may happen would be where a complainer, having given evidence in one trial, was subsequently cited to give evidence against the same accused in another trial, where that evidence was being led under the Murov doctrine to establish corroboration and a sufficiency of evidence for other offending. Currently, previous recorded evidence can constitute the witness's evidence in chief under the special measure of admitting a prior statement as the evidence in chief of the witness, but this would mean that the witness would remain subject to fresh cross-examination. Amendment 216 therefore allows for previously recorded evidence to be reused at a future separate criminal trial. This recorded evidence should be taken as the witness's entire evidence so that the witness does not necessarily have to be cross-examined again about their experience. It is still important, however, for the rights of the accused and for the interests of justice that an accused person can apply for the witness to be questioned further about their evidence. This question can be granted by the court in certain circumstances where there are questions relevant to the proceedings which were not previously put to the witness and could not reasonably have been expected to have been put to them in their prior examination, where refusing the further questioning would give risk to a significant risk of prejudice to the fairness of proceedings or otherwise to the interests of justice, and where that risk would significantly outweigh any risk of prejudice to the interests of the witness if the further questioning is allowed. Any additional cross-examination must take place at an evidence by commissioner hearing, which is a form of pre-recording of evidence that is held in a less formal environment with the benefit of a more focused questioning. Unless the court considers that an exception to this is justified in the individual case, this will ensure that the accused's right to a fair trial is protected while minimising the risk of re-traumatisation to the witness. Turning to my Amendment 217, the Criminal Procedure Scotland Act 1995 provides that in situations where a presumption in favour of pre-recording of evidence applies, the court can permit a child aged over 12 and under 18 to give evidence at their trial rather than pre-recording it if the child expresses a desire to do so, and if the court considers this would be in the best interests of a child witness. Amendment 217 would permit the court to also do this for children aged under 12 in order to further implement children's rights under Article 12 of the UN Convention of the Rights of the Child. Article 12 of the UNCRC requirements put an obligation on public authorities to give all children aged under 18 the right to express their opinions on matters which affect them, and for their views to be given due weight in line with their age and maturity. If the court is unable to grant an exception for children under the age of 12 based on their wish to give evidence at a trial, then it is unable to give due weight to those children's views. Permitting the court to grant an exception for a child under 12 does not mean that the court will be required to grant an exception, even if a child expresses a preference to give his or her evidence live. The court will still need to consider whether giving evidence would be in the child's best interest in line with the 1995 Act and with Article 3 of the UNCRC requirements, which states that the child's best interest should be a primary consideration. I move the amendments in my name and I would urge committee to support them and oppose Amendment 89. Thank you.
Thank you very much, Cabinet Secretary. Does any member wish to come in? No? Okay, thank you. Sharon Dowie to wind up and press or withdraw Amendment 89.
Thank you. I've taken on board the points that the Cabinet Secretary said. She's got amendments that should address my concerns, and I took on board the point that my amendment may overwhelm the system, which is entirely not to the intention that it's meant to have. So I will not be pushing. I'll withdraw the amendment.
Okay, thank you very much. So the members indicated they wish to withdraw the amendment. Does the committee have any objections? No. Okay, thank you very much. So I call Amendment 90 in the name of Sharon Dowie, already debated with Amendment 79. Sharon Dowie to move or not move?
Not moved.
Thank you. So I call Amendment 237 in the name of Jamie Green, already debated with Amendment 172. Jamie Green to move or not move?
Bear with me, it's been a long week. Not moved.
Thank you. I call Amendment 238 in the name of Jamie Green, already debated with Amendment 172. Jamie Green to move or not move?
Not moved.
Thank you. I call Amendment 239 in the name of Jamie Green, already debated with Amendment 79. Jamie Green to move or not move?
Moved.
Okay. So the question is that Amendment 239 be agreed to. Are we all agreed? No. Okay, thank you. We're not agreed, therefore we will move to a vote. So those in favour of the amendment, please raise your hands. Those against the amendment, please raise your hands. Do you have any abstentions? Please raise your hands. Thank you. Thank you. So we have 2 votes in favour of the amendment, 4 votes against the amendment, with 2 abstentions, and therefore the amendment is not agreed. So we now move on to the group entitled Victims' Statements. And I call Amendment 240 in the name of Jamie Green in a group on its own. Jamie Green to move and speak to Amendment 240.
Thank you very much, Convener. Good morning to committee members. Good morning, Cabinet Secretary and officials. This amendment 240 sits in a group on its own entitled Victim Statements. Amendment 240 would remove restrictions limiting the types of crimes in which victims are allowed to make a victim impact statement to a court. At the moment, only those who are victims of certain offences may make a statement to a court during solemn proceedings. Amendment 240 would seek to remove those restrictions, which currently limit the types of crimes in which victims can make such a statement. Essentially, it seeks to extend the franchise by allowing more victims the opportunity to provide a victim impact statement to court if they so choose. And those last few words are the important ones. I don't think any of us would believe that a victim should be forced to make such a statement. On a technical level, for the benefit of those new to this amendment, it does so by repealing sections 1 and 16 and removing the word prescribed from the term prescribed offence in subsection 2 of section 14 of the Criminal Justice Scotland Act. That's the means to the end. The reason for that is that the prescribed list of offences which allow victims to make statements was drawn up originally in 2009 and indeed excludes many new and quite serious offences which have been created since then by legislators and governments. For example, new offences around stalking, domestic abuse, aggravation, and I'm sure this committee will be familiar of the many wide-ranging changes that have been made over the last decade or so. So, of course, any new offences which could have, or which actually still could yet be created in law, are not covered in that prescribed offences list. Now, this feels to me a little bit, like a loophole, but also is by no means future-proofed. There is also a more important argument about why victims should be allowed to make statements to a much wider range of crimes, and that's the fact that the seriousness of a crime doesn't necessarily correlate with how that victim has been impacted by the crime. Let me explain what I mean. When I first consulted on this proposal in my own Victims Bill, Victims Support Scotland at that time, and this is 3 years ago, I think summed up perfectly why an amendment of this nature is needed. They said, the supposed seriousness of an offence often has little to no bearing on how the individual has been impacted. Therefore, in their view, anyone who has been impacted by a crime should be able to make a victim impact statement should they wish, regardless of the nature of the offence or the court in which it is to be heard. So that was the view of VSS at the time. Now, I agree with them. Now, I appreciate that the government may respond and indeed argue that this might be too big a jump to go from the current situation to perhaps an all-encompassing scenario where any victim in any court should be able to make a statement. So I am, of course, willing to work with the government and their officials. But essentially, I do want to expand the eligibility criteria and give more victims the right to make an impact statement in court proceedings. And I can't see why we wouldn't not want to do that. Thank you, Convener.
Thank you very much. Does any other member wish to come in? No? Okay, thank you very much. Cabinet Secretary.
Convener, I support the intention behind this amendment, which seeks to expand victims' ability to have their voices heard by the court by making an impact statement about how a crime has affected them physically, emotionally and financially. A previous consultation was carried out on this issue, the findings of which made it clear that there is appetite for change, such as widening the list of eligible offences and piloting new ways for victim statements to be made. There was also support for moving to a position where all victims should be able to make a statement in all cases. Currently, the right to make a statement which the judge must take account of in considering sentencing, as Mr Green has said, is limited to certain offences in solemn procedure, and I am very supportive of moving beyond that position. However, there are significant operational and resource considerations, particularly for the Crown Office and Procurator Fiscal Service, who coordinate the process of contacting victims and ensuring the statement is available to the court, and are responsible for ensuring that statements do not contain any inappropriate material, and for victim support organisations, as the composing of a statement can be a difficult time for victims, asking them to revisit the most traumatic aspects of the crime. These considerations were behind the introduction of a new power in March 2021 to enable piloting of both changes to the range of cases in which statements can be made and the way in which they can be made. Piloting enables these aspects to be tested and resource and operational implications to be better understood. An expansion of the victim statement regime, I can assure members, is currently under consideration. So I am supportive of the ambition of the amendment and agree that we want to move to giving victims the right to make a statement in all cases. However, I do not support making this move in one step at this time, due to the need to ensure that the resource and operational aspects are properly considered. This is particularly the case in relation to summary cases, as the volume of cases and therefore statements would be very significantly greater with associated resource implications, and there are also particular operational issues. For example, it is more likely in summary cases that an accused can plead guilty and be sentenced at the same hearing. A statement would only be sought from the victim following the guilty plea. To do so beforehand would raise false expectations for the victim and put them through the experience of revisiting the impact of a crime, potentially for no benefit if there is no plea or the accused is found not guilty. To do beforehand would also be an inefficient use of resources and would potentially lead to significant delay in those cases where a statement would then be sought and the plea and sentencing could then not happen on the same day. These types of issues underlie why it's necessary to take a stepped approach to widening the scope of the victim statement regime and consider at each point the variety of issues of introducing this in practice, including the resource implications for justice agencies and victim support organisations, what the impact on court programming would be, and also importantly the impact on victims themselves. However, I do recognise that there is a compelling case for ensuring that the voices of victims are heard and that they are given the opportunity to advise the court on the impact an offence has had on them. I am particularly keen that we take the first step of expanding this right to all solemn cases where there is an established process in place and therefore fewer additional operational considerations. There will of course be some resource implications, but this is an area I would be keen to discuss further with Mr Green, with a view to bringing forward an amendment at stage 3 to make this initial change on the face of the legislation. And I am also happy to commit to committee that we will carry out further engagement with the Crown Office and victims' organisations to inform the use of the piloting powers which would test further expansion. Thank you.
Thank you very much, Cabinet Secretary. So, Jamie Green to wind up and press or withdraw Amendment 240.
Thank you, Convener. Thank you, Cabinet Secretary. That's the best birthday present I've probably ever had, because I think what you've just elicited is an acknowledgement of a process and a practice that's not delivering for everyone in the justice system, an understanding of the issues, an understanding of the implications of the changes to it, and also a promise to seek to do something about it, and I couldn't have asked for more. So on that note, I'm very happy to work with the Government ahead of Stage 3 on a suitable amendment that expands the franchise for solemn cases, perhaps with a view at some point to look at the knock-on effect of how we could expand that too for summary cases. I understand the volume and the resource implications. Nobody wants trials to be delayed. No one wants to re-traumatise victims unnecessarily. but I think that step change is the right direction of travel, and I do believe there's probably some constructive consensus around the table and political parties in the Parliament to make that work. So I look forward to working with you and your officials to introduce this at stage 3. So for that reason, I won't need to therefore move 240, Convener.
Okay,
thank you.
Thank you very much. So the members indicated that they wish to withdraw the amendment. Does the committee have any objections? Okay, thank you very much. So I call amendment 241 in the name of Sharon Dowie, already debated with amendment 85. Sharon Dowie, to move or not move?
Not moved.
Okay. So I call amendment 242 in the name of Maggie Chapman, already debated with amendment 85. Jamie Green, to move or not move?
Ms Chapman has indicated she will not move that.
Okay, thank you very much. So I call amendment 243 in the name of Jamie Green, already debated with amendment 172. Jamie Green, to move or not move?
Not moved.
I call amendment 244 in the name of Jamie Green, already debated with amendment 172. Jamie Green, to move or not move?
Not moved.
Call amendment 245 in the name of Jamie Green, already debated with amendment 172. Jamie Green, to move or not move?
Not moved.
Okay, thank you very much. So we now move on to the next group, which is victims' rights in relation to parole process. And I call amendment 246 in the name of Jamie Green, grouped with amendments as shown in the groupings. Jamie Green, to move amendment 246 and speak to all the amendments in the group.
Thank you, Convener. Please bear with me. There are 11 amendments in this group, Group 13, and they're all, in their own right, pretty chunky. Group 14 similarly will address issues around the wider parole process. But essentially, all amendments in this group, and I'll break them down in a logical order, seek to improve victims' experiences with the parole process in a number of very different ways. And let me explain what I am hoping to achieve from these. All of these amendments were drafted after consultation and in consultation with many victims themselves, victim support organisations and victims campaign groups, some of which who helped form the wording of the amendments themselves.
Would the member be willing to take an intervention on that point?
Yeah, of course.
Thank you. One of the considerations, obviously, is the parole board itself's view, because they obviously have a great deal of knowledge of the operational aspects of this amendment. Has the member been able to ascertain what the view is beyond the organisations and individuals he's already mentioned?
Yeah, thank you for raising that. I think that's probably a good place to start before I go into the detail of the amendments. So, I mean, I'll say a few things. One is that my proposals that have formed the amendments today have been in the public domain since 2021. They were published as part of my Victims Bill consultation, and of which there were a wide range of stakeholders that responded to. All that's a matter of public record, and I won't bore the committee with the individual responses. But essentially, support for reform to many parole practices was around the 70–80% mark in each of the questions that I proposed in that consultation. I don't believe that the Parole Board responded to that consultation, although they had every right to be able to do so if they wanted to. Perhaps it's disappointing that they didn't. But I also would say that the issues that I raise are not new ones. And when I talk to the amendments, I'm sure anyone who's been a member of the Justice Committee for some time or paying close attention to the justice system in Scotland will know that these are not new issues by any means. They shouldn't come as any surprise to anyone. In terms of the Parole Board themselves, obviously, I'm no longer a member of this committee, and my locus in seeking their views and the evidence is limited. That's something perhaps that this committee has done or could do further. But I would say that I'm happy to work further with them between now and stage 3, for example, if they have a view on the proposals that are now in the public domain. And as a result of the OR today, I'm sure they'll be keen to hear the debate that we have. Because, yes, you're right, some of these amendments directly relate to them. I will actually, in some of the amendments, respond with comments made by the Parole Board themselves, who have expressed, I would say, an optimistic willingness for reform. and I have some quotes on the record that I hope will alleviate any concerns that this is somehow new news to the Pro Board. I think there's an appetite for change, and I will elicit some of that as I talk to the amendments as we go through them. Hope that's helpful. I'll start with Amendment 246 and power on through these, if you'll permit me. This asserts that a victim or a victim's family member, if the victim is deceased, for example, must be given the opportunity to observe parole hearings in relation to their offender's case. It does so by adding a new subsection into Section 17 of the Criminal Justice Scotland Act 2003, which states that a victim or their family member, I quote, must be afforded the opportunity to attend for the purpose of observing proceedings, oral parole hearings. Let me be clear what it does not do. A, it does not force a victim to participate in proceedings or hearings. I believe that they should always reserve that choice. B, it does not give the victims or their families the right to speak at hearings. And C, it does not give them the right to interrogate either the panel or the offender or their legal representatives. And I think that's really important that I put that on the record. What it also does do is it would give the Scottish Government additional powers needed as part of this reform to set out in practice how this might work. Now, for example, we saw during the COVID pandemic that a number of hearings took place electronically or remotely, and that ability to observe hearings was an established practice, and indeed technology made that much more simple and cost-effective and perhaps less traumatising for some victims. So that single path video link was available to some. That, for example, could be part of the regulations or the guidance which is given around this practice. Now, I appreciate that the Scottish Government may wish to consult further with the Pro Board on this specific proposal, but I think what is abundantly clear is that many victims feel excluded from the current practice. They, I would say, want to, but also deserve the right to observe hearings at the very least. Now, I also understand that it may be true that it may not always be appropriate for the victim to observe either all or some of a hearing. My amendments also account for this scenario. Subsection 2 of Amendment 246 does this. It makes it clear that the chairing member of the parole hearing retains the power to exclude a victim or family member from the hearing if they consider it appropriate to do so. In doing so, however, that chairperson must notify the victim or family member in advance and, more importantly, inform them of the reasons for their exclusion. Now, I think that's a fair and a balanced caveat to my proposals, and perhaps a much needed and necessary power to retain for the parole hearings. My amendment has the backing of many campaigners and support organisations who simply believe that what happens in parole hearings too often takes place behind closed doors. Whilst, of course, some victims can currently observe hearings, they have no absolute legal right to do so. And I think anything we can do to improve transparency is key. By way of example, I spoke just the other week with Ellie Wilson, who I know will be well known to this committee, who gave me a very specific example. When she was excluded from her attacker's parole hearing due to the fact that her attacker's lawyers objected to her attendance at the parole hearing. I understand that Ms Wilson raised this issue directly with the First Minister. It's well documented. It was reported at the time, and I stress it was reported, that his response was, I quote, that this decision was odd, strange and not very transparent. I agree, and I hope the committee does too. Amendments 247 and 248 both relate to the Pro Board's consideration of written statements made by victims. This is another issue which came about in my conversations with Victim Support Scotland. When the Pro Board asks a victim for a written statement, victims are left with a choice. They can choose to either A, relive the trauma and make a written statement to the board, often the same statement that's been written time after time after time, or B, they can choose not to have their voice heard in that hearing and risk the Pro Board making a decision without their input. This is exactly the opposite of trauma-informed practice, in my view. My amendments in this area seek to make that process more flexible for victims by maximising choice and minimising the chance of re-traumatisation. Amendment 247 does this by ensuring that the Pro Board has access to all statements made by the victim through the entirety of criminal proceedings, including the victim impact statement and the statement of crime from the initial trial, for example. It does this by inserting a new subsection into the technical bit, Section 20 of the Prisoner in Criminal Proceedings Act 1993, by requiring that Scottish ministers, when referring a case to the Parole Board, to send to the Board any and all victim statements made by the victim throughout the process of proceedings. And if that hasn't made sense, I'm happy to answer questions on it. Amendment 248 allows for a victim statement, whether that be a previous written statement or representations made to the Parole Board, police statements, victim impact statements, or any other formally recognised statement given during the process, to remain valid for as long as a victim wishes for that statement to remain valid. And again, I can go into detail about how it does it, but I won't. The point being is that Amendments 247 and 248 together allow the Parole Board to both receive and consider every and any statement a victim has made to a criminal justice partner throughout the process, be that from the initial police statement, through previous submissions, during the case itself, at the point of sentencing, or in earlier parole hearings. Now, the reason for that should be self-explanatory. Far too many victims are forced to re-traumatise and relive their experiences every time a parole hearing takes place. Now, we know that in many parole hearings, the offender knows fine well that their chances of parole are slim, but nonetheless will instruct their lawyers to push for one. At that point, I am told again through my conversations with victims that they are required to, again, time after time, often within a few short months, repeatedly submit victim statements to the parole hearings. Again, at the moment, the law does not seem to account for historic statements that have been made, and I think that is something that needs to be fixed, which is the purpose of those two amendments specifically. I'm going to move on to the next group, which is 252, 53, 54 and 55. Essentially, they all relate to delays in parole proceedings. And this is one of the biggest issues that came up in my discussion with victim support organisations, and that's really how damaging that delays to parole proceedings can be to them and their recovery journey. There is, unfortunately, and we've tried, a real lack of statistical evidence that relates to the amount of delays or the length of delays to parole proceedings. It's very, very hard to unearth that. Despite that lack of statistical evidence, I do know that anecdotally, through my discussions with victims, and I'm sure this committee has taken evidence of this nature, delays to parole proceedings are exceedingly common. I understand that they can be delayed for a number of reasons, and it's not always any organisation's fault for the delays. But Amendments 252 and 253 seeks to place a reasonable but statutory duty on both the Prison Service and the Parole Board to ensure that delays to hearings are minimised and avoided as much as possible. Amendment 252 places a duty on the Parole Board to, I quote, take reasonable steps to prevent any delay in scheduled oral hearings by ensuring, again I quote, that the documentation required for the hearing is prepared in advance of the hearing. That may sound like stating the obvious, but it's clearly the case that that does not always happen, and that is one of the reasons that hearings are delayed. Amendment 253 places a similar duty on the Scottish Prison Service to provide the documentation required for the hearing to the Parole Board no later than 7 days before the hearing. Again, anecdotally, some of the rationale given for delays to parole hearings is that the information required to allow the Parole Board to make a decision was not given in a tedious fashion by the Scottish Prison Service for a number of reasons. The reason, anecdotally, again, most often given is workload and the SPS's focus on their core duties insofar as looking after the current prison estate and those contained therein. So we do know that delays happen, and we do know some of the reasons why they happen. I would like to put both of these statutory duties into Section 20 of the Prisoners in Criminal Proceedings Scotland Act 1993. Victims also tell me that when these delays happen, they receive little to no notice. Unfortunately, victims find out often after they've already arrived at the prison where the hearing has taken place. Now, to me, I'm afraid that is simply unacceptable, and that is absolutely not a trauma-informed way to manage parole. Amendments 254 and 255 will offer the committee two options that would require the Parole Board to notify a victim as soon as is reasonably practical of any delays to proceedings and the reasons for such a delay. Now, this doesn't have to be anything onerous or in writing. It could even simply be a phone call. But what is important to me is that the victim is informed at the earliest opportunity there is a delay to the hearing. Amendment 255 does this by giving the Scottish Government the power to require the Parole Board to notify victims if the hearing has been delayed. Amendment 254 does the same thing as 255, but does it in a slightly different way. Instead, this amendment places requires that the Parole Board informs the victim of any delays to proceedings and provide a reason for the delay. They go about it in slightly different ways. I believe that 254 does it in a slightly clearer way, but I'd be interested to hear what the government has. And again, I offer the committee both options as a means to the end. I want to talk about my experience last week when I met with Linda MacDonald, who again I'm sure many of you will know, and the Cabinet Secretary will know her story, who was attacked in 2017. That was certainly a very emotional experience for me as I go about coming with what are quite technical amendments. But in the long conversation that we did have, one story really struck me, which I think drives the underpinning for this amendment, is that when her attacker was up for parole earlier last year, Linda travelled from Dundee to Perth to observe the parole hearing, only to be told that the hearing had been delayed on her arrival in Perth. Fine. She complained to the Parole Board, who told her that she should instead complain to the Scottish Prison Service. She complained to the Scottish Prison Service, who told her that actually she should complain to the Scottish Government's Victims and Witnesses Unit. It's an endless loop, and being passed from pillar to post in that situation is, in my view, unacceptable. She hadn't been informed of the parole hearing delay until after she travelled to the prison. That should not be the case. Parole hearings can be distressing and traumatic for victims. They can necessitate time off work. They may require organising support networks for them, and if they choose to physically travel to and from the parole hearing itself. And that's the rationale behind Amendments 254 and 255. And finally, in this group, you'll be pleased to notice 262, which is a slightly different amendment. I'm not sure why it sits in this group, but it's about reporting requirements on bills. I'm sure we're all used to seeing these pop up in legislation. But this is a very simple reporting requirement that will ensure that the Scottish Government will undertake a review within 1 year of this bill coming into force on the wider parole process and how it can become more trauma-informed. That's essentially what it seeks to do. I would ask that the Government would take an end-to-end review of the parole process, taking into account, for example, the information that is provided to victims, the ability of victims to attend or participate in hearings, the level of participation that victims have afforded to them, and how we can make the whole process more trauma-informed. And in light of my contributions this morning and other amendments by other members, it's clear that the current parole process does not always work for all victims. It often leaves them feeling excluded and re-traumatised. So we need to fully understand what we're getting wrong in order to get it right. And I think my amendments in this group will kick off that much-needed and long overdue conversation.
Thank you very much indeed. Does any other member wish to come in? Rona Mackay.
Yes, if I could please. I'd just like to go back to the group about decisions to release prisoners, and specifically Amendment 251. You haven't spoken to that. It's coming up. Yeah, I thought I'd missed it because there's an important point I want to make to that. So, apologies.
Okay. No, that's fine. Yeah. Thank you, Pauline McNeill.
Thank you. So I wasn't able to attend it, but the committee members did attend a private session where this issue was raised. It strikes me that, given the importance and the detail that Jamie Green has gone through, it does expose, I think, the need for there had to be something included in this bill in the first place. Because what Jamie Green is speaking to is the similar theme that we've been dealing with as a committee, is that trauma that victims experience in the Criminal Justice Committee. So it does seem an omission. within the bill itself. Jamie Green's not going to be surprised that what I'm going to say is that it would be difficult to make a judgment on whether this is the right thing to do without having heard from the parole board itself, of which the committee have had, no, I don't think in this session, had any contact at all. And maybe in summing up, Jamie Green could see whether he's had any discussions with the parole board. So I'm not really familiar with the full processes of what they do or what they don't do. I'll just lastly say, it's, in my opinion, it's one of the reasons that, well, there's two things. One, it does expose the failures of the Stage 2 process as a whole, actually. That we are so bound by, obviously, the Scotland Act on this, and someone has to give some thought. I believe some committees of the Parliament are giving thought to how to change it, but I think this is a good example to look at. An issue that's really big, not included in the bill, and we can't take evidence that easily before Stage 3 on something which is now proven to be really important. And lastly, it's been my opinion since the beginning of dealing with this bill, it's far too big. The committee members, regardless of our positions, will all probably testify to the fact that huge issues contained within this bill, in one bill, and now it seems that if you wanted to focus on victims and trauma, then I would have thought there was a case just for doing a bill on that alone and leaving some of the issues to deal with separately. I will take an intervention, yes.
As always, I don't sit week in, week out in this committee anymore, but I do hear what the member says. I mean, bear in mind, this is the victims' bill. You know, the point of it changing from criminal justice reform to a victims' bill was exactly that, I believe, that the government understood there was a refocus on some technical changes to the judicial system, some of which are substantial, but equally that it was an opportunity to improve you know, practices within the justice system, including the parole process itself, which seems to be a major common theme that comes in victims. So I don't think necessarily any of this is new. I don't know the reasons why the committee didn't take evidence on parole. I don't know why the Parole Board of Scotland hasn't engaged with the committee on it. That's, you know, for the committee to understand. But at the end of the day, this is the only bill that's on the table at the moment. You know, I could absolutely come back with a bill that's solely focused on this, on parole and reforming parole in the next year, but I don't think we'd have time. I don't think the committee would have time, I don't think Parliament would have time. So this is the only bill in town at the moment, and this is why I'm using this bill to do that. Now, what I would hope the committee would do is that if they felt... but if they felt this was an important issue, is that they could have the ability to take further evidence ahead of Stage 3. That would be really useful and important.
I mean, I think the member is certainly not going to contradict me on if it's not in the bill at the moment. So that's why we didn't take evidence on it. And just so we're clear, I fully support pretty much all that you've said. But as somebody who's here to scrutinise, what I would like to have done is heard evidence or even had the chance to talk to the Parole Board. That is my only issue here. So I didn't design the bill, the government designed the bill, so this is where we're at. And that's my view, the bill is too big and it makes it more difficult now. And the process at Stage 2 is very difficult because this committee have argued for more time successfully, you'll see that. So I'm very supportive and I'm not going to vote against these amendments today. I'll hear what the Minister has to say, and that's because I think there's an awful lot of merit in what you're saying. But I think, I don't know if you can answer, if you've had any discussions with the Parole Board to get, is there anything that you could help the committee with when it won't be out the committee's hands, obviously after today it's for the full Parliament, but I think as much information before if we're going to make a decision at Stage 3 would be helpful. Thank you.
Thank you very much. And I also am very sympathetic by the amendments that Jamie Green has brought today and what he's been trying to do. And I appreciate that he has already put a huge amount of work into this in his members' bill, which of course is not something that the committee has had the opportunity to scrutinise in any detail whatsoever. As Pauline McNeill has said, these are not matters that were in the bill that was put forward by the government, and therefore were not matters that were considered by the committee as part of our Stage 1 proceedings. I know that campaigners are doing a huge amount of work, and indeed have met with the Cabinet Secretary and the First Minister. It may be some time before we have another opportunity to consider these matters. It's unlikely that there'll be another bill in this Parliament that would be able to take these issues forward, and I therefore would urge the Cabinet Secretary to engage constructively with this issue to see if it is possible to bring something forward in this bill. But we do need to make sure that we have appropriate scrutiny mechanisms, and I think that's something the committee needs to consider, and I would want to ensure that the committee has the full opportunity to properly scrutinise any amendments that are brought forward, whether that's by the member Jamie Green or indeed by the Scottish Government, because these are important matters that we need to get right. There are rights which exist in many other countries. Many other countries give victims rights of this nature, but we have a specific legal system in Scotland that we need to make sure works. And I think it's difficult to do that without having the information that's been highlighted this morning. So I appreciate the work that Jamie Green's doing, but I hope it is possible that at the end of the day we're able to come forward with some kind of amendments that could be supported by the Parliament.
Thank you very much. Okay, Cabinet Secretary.
Thanks very much, Convener, and well, happy birthday, Mr Green. You did cause me some anxiety when you said there was 11 amendments in this group. Can I just put in the record that there's 8? Oh, right, that's nice. Yes. And I also want to begin, Convener, by recognising Mr Green's long-standing interest in these issues and indeed his commitment to securing improvements for victims and the family members of victims, particularly in their interactions with the Parole Board for Scotland. And I absolutely share Mr Green's ambition for a victim-centred, trauma-informed approach. And while there is much to commend in current practice, I absolutely accept that there is much more we can do. We do, however, need to make sure that in embarking on reform that we do so holistically and in a way that reflects and maximises all of the levers we have for effecting change. And that's why I can confirm to committee this morning that I will be publishing a consultation in August with work being carried out over the summer on parole reform in Scotland, building on the changes to the Parole Board Scotland rules that were made in 2022. And I just hope that by committing at the outset to consult on some of the wider issues, it is clear that I am not only open but willing to make the necessary changes to the parole process to command the confidence of victims and their families. Now, that is not to say that I don't see a role for this bill in bringing forward change. I have looked constructively across the suite of amendments in this group to identify where I think we can commit to legislative reform to make a meaningful difference. There are, however, some intricacies that I would want to work with Mr Green on before I could support those amendments. So whilst today I cannot support them as drafted, there are many I would be very keen to work with him ahead of stage 3. So turning to the specific amendments in order. I absolutely accept the principle of Amendment 246, which seeks to ensure that victims or their families are given the opportunity to attend oral hearings. I recently, as Mr Green mentioned, met with survivors who spoke compellingly about the importance of that opportunity. And some victims are already afforded that opportunity in the current system, and changing these rules can be achieved through reform of the Parole Board Scotland rules, and I fully intend the upcoming consultation to include consideration of whether this aspect of the system is working as it should or whether we need to revise those rules. And I would therefore ask Mr Green not to press the amendment and to allow the consultation to run to gather the widest possible range of views on the matter. I also agree with the principle of the provision of victim statements and written representations. In Amendments 247 and 248, victims should have their voices heard and should not unnecessarily have to repeat their presentations. And I agree that there is more we ought to do to ensure effective processes, and it may be that primary legislation has a role to play. We do, though, need to ensure that these amendments have the intended effect, and as such I would ask Mr Green not to press these amendments and instead discuss with me in advance of stage 3 to see if we can come to an agreed position. Of course.
An indication from the Cabinet Secretary as to her thinking in terms of timescales for any proposals that the Scottish Government may be able to bring forward. In particular, is it likely to happen before the 2026 elections?
So, as I hope I'll be able to demonstrate as I go through the group, where I can indicate where we can work ahead of stage 3, so that would be progress that we could make in the context of this bill. If we have the consultation in August to revise parole board rules, I think I am correct in saying that any revision of parole board rules, obviously depending on the content of the consultation responses, that requires a SSI, which obviously is less onerous than primary legislation. So at the risk of giving a maybe's aye, maybe's no answer, and I appreciate that may be less than desirable, but depending on the nature of the responses, it could be possible that a further revision to parole board rules could take place prior to the 2026 election. I just don't want to be hard and fast about that until we proceed with the consultations, because some of this should be considered holistically and in the round. So, sorry, forgive me. Yes. In relation to 252 and 253, I have considered these very carefully, and while there is no difficulty with the underlying objectives of seeking to reduce delay of oral hearings, ultimately these are operational matters and are most effectively addressed through improvement work rather than being mandated in legislation. I do know that where possible, the Parole Board for Scotland already takes steps to prevent delays in hearings taking place. However, there will always be instances where circumstances, to be fair, are out with the Parole Board's control and which are difficult to foresee or plan. I am also satisfied that every attempt is made to ensure that all parties have access to the appropriate documentation in advance of the parole hearing where this is possible. But can I just say that endless loop that Mr Green outlined in his opening remarks, if I can make clear, I find that utterly unacceptable. What victims need from all parties in the justice system is for people to work together in the spirit of collaboration, and I find it deeply unhelpful when different parts of the system point the finger at other parts, and we need to perhaps embed a different culture of collaboration, and I am committed to supporting all parties to be able to do that. I mean, they are all parties in the justice system are, of course, working under tremendous stress. I don't want to be interpreted as being chastising in my remarks. But I think it is fair to say that I think all parts need to do better. We can't have people pass from pillar to post. We need to be clearly articulating the different roles and responsibilities of different agencies and partners in the justice system. But this endless loop of passing folk from pillar to post is just not acceptable in my view. And of course, in terms of delays, Mr Green is right. There isn't any statistics available on this, but I would be willing to explore whether there is performance management type information that would give us better information on that. But again, I really don't see that is an issue for legislation. So for those reasons, I would ask Jamie Green not to press amendments 252 or 253, and if he does, I would ask members to oppose. Amendments 254 and 255 seek to ensure where a hearing to consider a prisoner's release is delayed or cases are delayed, that victims are informed of that delay and the reasons for it. Again, I broadly support the intention behind these amendments and would like to discuss further with Mr Green to see what, if anything, could and should be done through primary legislation ahead of stage 3, or whether or not his attention could be achieved through reform of Parole Board Scotland rules. Therefore, I would ask Mr Green not to press these amendments and to work with me ahead of stage 3. I acknowledge that there is an ongoing need to review and improve the parole system and help ensure it is more trauma-informed and inclusive of victims. However, I do not consider a statutory review, as Amendment 262 would dictate, as the most effective way of supporting this, and it could delay existing improvements. In addition, I would also remind members that Part 2 of the bill makes important changes to the reporting requirements for Parole Board Scotland. The board must already annually report on how and to what extent the standards of service for victims and witnesses have been met, and the bill will now include reporting in relation to their standards on trauma-informed practice. To conclude, Convener, I would ask Mr Green not to press the amendments in this group and to work with me where I have indicated in advance of stage 3 and on the other areas to note the upcoming consultation and the ongoing improvement work.
Okay, thank you very much, Cabinet Secretary. So Jamie Green to wind up and press or withdraw Amendment 246.
Thank you, and can I thank committee colleagues for your helpful feedback and that discussion around scrutiny, which I think is a really important one. You'll know, certainly from my time in committees, that I'm always calling for more time for bills to make sure we get the widest range of people sitting at the end of that table feeding back. Of course, I would also make that invitation to any justice partners out there who are following proceedings. These amendments are, again, a matter of public record. If they have a view on them or the comments made today, I would encourage them to engage with the committee on their feedback. What does the Parole Board think of my proposals and changes? I would like to know too, as would the committee. And if things are achievable in a relatively short space of time, then that's great. If they require legislative change, then so be it. Again, I am, the reason we're doing this now is that we're almost in April 2025. The window of opportunity to do anything this parliamentary session is now, in my view, and I certainly don't want to kick this down the can into the next session of Parliament and end up in another, 5 years debating the same things. I think victims deserve better. But just to recap on what the Cabinet Secretary said, just so that I'm correct when it comes to moving and not moving, the Cabinet Secretary has indicated that Amendments 246 and 247 could be achieved without primary legislation, but through changes to Parole Board rules, and that the next stage of that would be a consultation process. I suspect that process would happen after the passing of this bill, however, so I guess we would need some confidence that that consultation would not just be a consultation, but would lead to meaningful changes in the Parole Board rules. If we're not going to do it on the face of this bill, it has to happen somewhere down the line. So I guess it's just some comfort there. Yeah, of course.
Yeah. I suppose just for clarity, if it's helpful, in terms of 246, in summary, I'm seeing we accept in principle, but that is an important issue for the consultation, which will take place in August, and we have the vehicle of a statutory instrument. So I hope I've demonstrated that, without prejudging the consultation, that there is a willingness to proceed thereafter. In terms of Amendment 247, 248, I'm saying let's look at for stage 3, and in terms of 252 and 253, I'm just saying that's not appropriate for primary legislation. And 254, 255, accept in principle, let's discuss it at stage 3, okay. And I am resistant to 262, the statutory review.
Thanks very much. That's exactly the summary I was hoping to achieve. That all makes complete sense, and I'm very grateful of the opportunity to revisit some of these ahead of stage 3. of course I will do so, and hopefully we can bring some of these changes back on the face of this bill. But against the point that the Labour members have made, absolutely, that scrutiny, the opportunity for scrutinising any amendments that come forward, either from me or from the government ahead of Stage 3, that everyone's had the chance to feed into those amendments and the effect they might have. And as they will come back to the Parliament as a whole, that that information will be available to all MSPs. And I'm sure that the government and I can work on those together to ensure that members are informed and that due consultation, if needed, takes place ahead of Stage 3. Appreciate it's a tight window of opportunity, but again, we need to know what effect these things have on justice partners. But that willingness to work with me will be warmly received by many of the people that I know are watching this session this morning, and very grateful for it. Thank you.
So can I just confirm if you want to press or withdraw Amendment 246?
Bear with me. Withdraw.
Thank you. The members indicated that they wish to withdraw the amendment. Does the committee have any objections?
No.
Thank you. So I call Amendment 247 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
Not moved.
I call Amendment 248 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
Not moved.
Okay, right. Okay, thank you very much. So that's just coming up to 11 o'clock. And can I suggest to members that we have a short break for 10 minutes and therefore I'll suspend the meeting. Thank you. Okay, thank you very much. So we now move on to the group entitled Decisions to Release Prisoners. And I call Amendment 249 in the name of Jamie Green, grouped with amendments as shown in the groupings. Jamie Green to move Amendment 249 and speak to all amendments in the group.
Thank you, colleagues. Again, I'll try and rattle through what are quite a lot of amendments in this group. Just checking how many they are, Cabinet Secretary, so you don't get me into trouble again. There are 9 in this group, of which 7 are mine. I think that's correct. Okay, I've grouped these amendments in a particular order so that I can speak to them on block by the function of what they're all about. But essentially, this group is entitled Decisions to Release Prisoners, which ultimately is one of the end results of a parole hearing, a decision to release or decision not to release. And there's quite a lot in here. But the first set of amendments that I will talk to are around 249, 251 and 260. And these all relate to the central factors that I believe the Parole Board must take into account when considering a decision to release a prisoner. There's good reason for this. I believe many victims feel that there is a lack of transparency and, on occasion, logic behind many of the decisions made around the release of a prisoner. Of course, not everyone will always be happy with those decisions. But one overarching theme that's come through over my last couple of years in discussing this with victims is that the safety of victims and their families must be the principal driver of a decision on whether or not to release an offender. With that in mind, committee members will note that all the amendments in that subgroup start in the same way, and they do so by amending the Prisoners in Criminal Proceedings Scotland Act 1993. Now, the Act already states that the Scottish Government can set out which factors may be taken into account by the Parole Board. That is fine. But I want to go a step further. I'd like to see on the statute books the factors that the Parole Board must take into account, the things that must be central to that decision-making process. Amendment 249 is, in my view, the most important one. It states that one of the matters that the Parole Board must take into account is what the impact of a decision to release a prisoner could have on the safety and security of a victim and or their family members. Now, this amendment was a key part of Michelle's Law, which was a subcomponent of My Victims Law. It was so named after Michelle Stewart, a well-known case. Michelle was tragically murdered in 2008. Her killer was released in January of this year, actually. Now, Michelle's family, to their great credit, and through very difficult circumstances and times, have spent many years campaigning for the welfare of victims and that for the family's views and feelings are taken into account in parole decisions. And that's really what underpinned a lot of that section of my original consultation. We hear so many of these laws named after people, Michelle's Law, Suzanne's Law, which I'll come on to talk about. There are many of them. The common theme, of course, I've said this before, is that they're all named after women who were the victims of horrific crimes, and some of them tragically murdered. So really, that underpins the sense that the whole parole process should be aimed at making a decision as to whether the Parole Board believes that the victim of that crime or their family will be safe upon the prisoner's release. When I consulted on this very specific proposal, which is translated directly into Amendment 249, this proposal received 82% positive response rate from respondents. One organisation, who I'll mention, and it's on the public record, so I'm sure they won't mind, is a group called Support After Murder and Manslaughter. In their response to my consultation, they said the following: bereaved families are often and usually terrified of coming face to face with offenders after they are released. There is a very real fear that families live with every day, and they can be deeply traumatised by the possibility of seeing the offender. Now, of course, the government may argue that, of course, parole boards already take into account the safety of victims and their families as due consideration as part of the parole process. If that be the case, then why is it so that many prisoners leave prison and then go on to harass, abuse, assault and even murder within weeks or even days of their release? I believe that putting the safety of victims as the principal decision marker on the face of the bill, we can offer victims and their families some much-needed cast-iron assurance that their safety and security are taken into account at all times by the Parole Board. Amendment 251 is another of these matters, in that the Parole Board must take into account, I quote, any remorse shown by the prison in relation to the impact of the prisoner's offence on any victim of that offence. Yeah, I'll tell you what, let me explain the amendment first, and then I will bring you in and happily hear what you have to say. Now, contrary to what some media headlines suggested, that victims calling for an amendment of this nature, essentially that a prisoner should show remorse as part of the consideration of their release, we're not suggesting that we force an offender to admit guilt in order for parole to be granted, because that would be wrong and probably illegal. Nor are we saying that if you do not admit guilt, having been sentenced to a crime and spent that sentence, that you will be denied release in perpetuity if you do not admit guilt. Now, some people actually morally argue that if you do not admit guilt or express explicit remorse, then you are therefore not truly rehabilitated and therefore should not be released. Now, that is a school of thought that's in the public domain. And I have some sympathy with that, but I also understand that there would be huge swathes of defence solicitors and human rights lawyers lining up to counter such proposal. I am not doing that, and I must be clear in this amendment. Instead, I propose that if an offender refuses to demonstrate remorse or to acknowledge the hurt and pain that they've caused the victim, then that should be a major factor to be considered by the Parole Board. Is this person truly fit to be released if they express no remorse? I think this was best put by another victim of crime, Hannah McLaughlin, who I know that the committee has also heard from around this matter, when she was quoted as saying that it is that validation that the offender is taking responsibility for what they did. And I agree. So that's the difference between what has been mooted, is what this amendment seeks to do, and what it actually does in black and white. And I wanted to make that absolutely clear. And I'm happy to take an intervention at this point if it's helpful.
Thank you for taking the intervention. I have, huge sympathy and agree with the intention behind these amendments, and particularly with regard to witnesses' safety and their families. The concern I have about the remorse issue is that have you taken into consideration people with communication difficulties or who may be neurodivergent and actually struggle to show remorse in that sense? Their behaviour in prison might have been exemplary, but they just can't get that over to the Parole Board. Mm-hmm. And the converse is true, for some prisoners that can articulate but maybe haven't, shown a great deal of progress in prison. So I think it's really important that there will be a high number of prisoners in that category. So I think it's important that that's taken into consideration.
Yeah, that's a very good point. I think there are ways and means to do this. I mean, we have to put some faith in some of the pre-hearing reports that are considered. If anyone within justice partners are engaging with the offender in advance of the hearing, whether that be SPS staff, clinical psychologists, any third party that's engaging with the prisoner, I'm sure we've all, off the back of the recent TV show Adolescence, about the key role of someone assessing an individual who's been, who's committed a very, very grave crime, is that there are ways and means to elicit their understanding of what underpins that person's attitude towards the crime they've committed. Now, for someone who has communication difficulties or additional needs, for example, I still believe it's possible to demonstrate remorse. And more importantly, there is still I believe there should be a moral obligation to do so. But again, if they're unable to, it doesn't prohibit their release, nor will it ensure that they are kept in prison. It's simply one of the factors that the parole hearing must take into account. And that's what campaigners are asking for. Now, that some are asking to go a lot further than that, and I accept that that may be difficult, and I'm sure that I'll be interested to hear what the Cabinet Secretary has to say on that. You know, I don't sit in those parole hearings. I don't know what all the information that a parole board will have in front of them, but I'm pretty sure that I have some faith that the parole board themselves, the committee members of the hearing, should and will request all access to information that they deem necessary, and that may involve some extra support in those scenarios, those very particular scenarios.
On that point?
Yeah.
I thank Jamie Green for his comments so far, and I think I'm particularly enjoying listening to you explaining both sides of the case. I think that's actually very helpful to us as a committee when we decide how to vote. I think Rona Mackay's challenge is a reasonable one. However, I'm just looking at your Amendment 251, Mr Green, and it reads to me as though Section 2, subsection B, is simply saying that the board must take into account any remorse. So as they're coming to a decision, they're having to weigh up any remorse that's been shown. By extension, doesn't that mean that they would have to also take into account any of the challenges that Rona Mackay's put to you, and therefore it's not fatal to the amendment that someone may have these difficulties?
Yeah, I think Rona Mackay's right to raise that. You know, we all know that the nature of the demographic of our prison population and some of the challenges that are presented within many offenders groups, subcategories, and I think those are common themes that run through. And I think, you know, there absolutely are some people in prison who may struggle to verbally demonstrate remorse, even if they want to. And I think that's part of that process. But I think, you know, we have to put also some faith in the parole process itself, that those people will make an informed decision based on their experience of listening to offenders in those scenarios, and also using some gut feelings. There is probably a huge amount of that involved in these decisions. Again, my amendment actually is quite a simple one in this respect. Yeah, in a second, yeah. But I mean, it simply is just remorse shown by prisoners. And it says that they must include a provision that the parole board must take into account any remorse shown by the prisoner in relation to the impact of the prisoner's offence on any victim of that offence. So it's to take it into account. It's not the deciding factor. And again, I want to make that clear.
Thank you. I understand that, but I think your amendment runs the risk of having a bearing on a decision. That because it's there, it might just sway this on someone who just can't articulate themselves, and that's my concern.
Yeah, and on that, I am unapologetic in the premise of the amendment is that I believe that it should have a bearing on the decision. If that answers your question. Oh, sorry, I didn't spot that. Yeah, of course.
Yeah, thank you. It's these amendments that give me a bit more cause for concern, because it's not that I disagree that it should be taken into account, but it is as much to do with the release of prisoners as it is about victims, of which, again, we haven't had much opportunity to understand the whole basis of which prisoners are released, other than they have the opportunity, 50% of their sentence or 2/3, to go through the parole board. Do you happen to know if remorse is a consideration at the moment? I presume that orders for lifelong restriction don't go through that process, so that they wouldn't be included in that. Because I don't know the answer to that question. I would be surprised, I suppose, if there was no at least passing discussion with the Pro Board as to whether remorse was a factor. I know do know in relation to orders for a lifelong restriction, you will see psychological reports drawn up where remorse is a factor because they are considering risk to victims, but also risk to communities, the wider risk to communities, because it could just be, there could be a victim, there could be more than one victim, or it can be risk of harm to communities, which is, I imagine, a different consideration, albeit it's a question of safety, risk and all the rest of it. So I think you can see where I'm going with this. There's a lot of complexity, I think, to this debate. It's, whilst I could, if the government come back on stage 3, which I think they are on the other amendments, I'm content with that. But this, I feel that it's much more than the impact on victims. I think there's a whole mechanism about the process release for prisoners. It does surprise me, to be honest, that you got it in, to be honest, because it is about the release of prisoners, actually. But it would be helpful to know if that is a consideration by the Pro Board already or not. Thank you.
Thank you. I'm sure we'll find out very shortly in the Cabinet Secretary's response to my amendments whether that is a consider. I suspect the answer will be yes, which is good news, and therefore this debate is important. But the Amendment 249 actually was the more simple of these, because it is absolutely all about the effect that a prisoner's release has on victims and their safety and security. And I don't actually think that should be a point that's up for debate. I guess and I think we probably all agree on that, I think the point that I'm making with this amendment is that it is a principal factor in the decision-making process, because I think many victims tell us that it is not, quite frankly. I've actually got a lot of amendments in this group to get through, so maybe I'll rattle through them and perhaps members can come in with other contributions as we go along. I want to move on to another amendment, 260. I can point members' attention to that, and I'll speak to that in a sort of mini group on its own. This one requires the Pro Board, when considering the release of someone convicted of murder or culpable homicide who has not disclosed the location of their victim's remains, to take this into account before making their decision of release or otherwise. This amendment is better known as Suzanne's Law and was another very key aspect of my original Victims' Bill consultation. It attracted 84% support from respondents to that consultation. Suzanne's Law, as I've rehearsed before in the Parliament, was named after Suzanne Pilley, who again was tragically killed in 2010. And again, unfortunately, her body's location has never been disclosed by her killer. The wider expectation is that that individual may be up for parole in a couple of years. But Suzanne's family campaigned very vociferously and valiantly on this issue. It is with regret that Suzanne's father passed away in 2019 without ever knowing where his daughter was buried. However, thereafter, Suzanne's sister did tell the BBC this, and this is really what underpins this amendment. For the past decade, we have lived in a state of limbo, waiting for the news that Suzanne's body has been found, but we've never been able to get that closure. We accept that she was murdered and believe that the person responsible for that is in prison, but we cannot say proper goodbye until her body is found. Now, when I first mooted an amendment of this type, we looked at numerous, and I must say numerous versions of it, which spanned quite a wide spectrum of legislative change, because there is a spectrum of views on this. At one end, people believe that the release of a murderer should automatically be denied if they have failed to reveal the location of their victim's remains. Others argue that this absolutely breaches a whole heap of international laws and human rights, and indeed sits outside the competency of this Parliament. There are a wide range of views in the middle. I probably sit in the middle, and I've sought to come up with a middle ground on the face of this bill. I've tried to find a pragmatic and realistic compromise, one which does not automatically block the release of a prisoner, but nor does it agree that the status quo is fair to the relatives of those victims, such as is the case with Suzanne Pilley's family. So I believe that we can meaningfully implement Suzanne's law, and I believe that this amendment will do so, and I hope we'll get the support of the Government and the Committee for it. On a few other perhaps less substantive amendments, again covering some of the issues I've already raised, those were about release of prisoners on licence, for example. I've also tried to cover off the issue of temporary release, because we know anecdotally of issues where some offenders have been released or have been given temporary release for various reasons and committed crimes. Amendment 250 requires that the Governor of a prison must consider, prior to deciding whether or not to grant temporary release, what impact this decision could have on the safety and security of a victim or their family member. Again, I do believe that this often happens in prisons and that governors are aware of their obligations in this regard, but I believe it is essential to put it on the face of legislation due to some well-publicised failings in this regard. In fact, when I go back to the Michelle's Law example that I quoted earlier, her family, I've since discovered, only knew that their daughter's killer had been granted temporary licence by reading about it on social media. Again, that's just not acceptable. Again, I refer to my other conversation with Linda MacDonald, who I spoke about in another grouping. And many victims are saying the same thing, that in any scenario where someone's released from prison, be it temporary or otherwise, that the safety and security of the victim and their family should be a key consideration. Given that these decisions are made by governors, Amendment 261, again, when considering temporary release to someone convicted of murder or homicide, off the back of 260, must take into account whether that or not that prisoner has disclosed the whereabouts or remains of their victim. That's linked into Suzanne's law as well. So again, I'm hoping that the government will consider those. And finally, importantly, is Amendments 256 and 257, and this is about transparency and openness in the parole process. Amendment 256 states that the parole board must provide a victim with a summary of the reasons behind their decisions, whether that is to release or not release, or to impose conditions or not. It does so by inserting this requirement into Section 17 of the Criminal Justice Scotland Act 2003. Now, when I originally consulted on this issue, my original question asked respondents as to whether they supported that the victims of crime should have access to the reasons in full as to why the parole board has come to their decision. That was met with 86% positivity response rate, which tells me there's an appetite for more decision-making and the reasons to be given to victims. Victim Support Scotland, specifically in response to that question, which, by the way, goes much further than the amendment I'm pursuing today, said as follows: the victim being released can cause significant anxiety and distress. Where the parole board does decide to release somebody, the least victims deserve is, where they wish it, an explanation of the reasons behind this. I think it goes without saying that transparency and improving transparency around decision-making is fundamental to restoring full trust and confidence in parole hearings, which again often take place behind closed doors. Now, of course, the victims may not be content with the outcome of a parole decision, but there absolutely is a greater desire for the rationale to be offered to victims as to how and why those decisions were taken. I also believe that there is an appetite within the Parole Board of Scotland to do so. And I'm happy to circulate this after the meeting, but there's a very interesting interview that took place between the Parole Board and the Courier newspaper in August of last year. At the time, the Chief Executive of the Parole Board was quoted as saying, "Our position, I think, is that we are quite happy to publish all of them, every single decision, but there may be a resource implication." That's fair. The Parole Board Chairman, John Watt, was quoted on the record as saying I think it would be important to generate an understanding. It wouldn't be beyond, I wouldn't be beyond going a bit further and giving some broader context for these decisions. If we were able to, we would be quite happy to extend the categories of case where we give summaries, for example. They went on to say, to talk about the anonymisation of the publication of decisions, again, something I'm going to look at in the next amendment. So I think, on the record, this goes back to a point perhaps Ellie made about what did the Pro Board think about some of this. Well, they're already on the record some 7-8 months ago as to, when asked about such changes, as to giving some positive feedback, there is an openness and a willingness to do so, and I think that's very good. It's a very good starting point. Amendments 256 and 257 are the last two of mine in this group. Again, essentially they're trying to ensure that there is more transparency in the public domain. Amendment 257 particularly is about the publication of decisions. Now, some decisions are already published online. The public can go in and look at those, but there are many decisions which are not. Of course, they are anonymised in many cases for good reason, insofar as it's required to protect the identity of victims or witnesses, or perhaps if the chairing member considers it appropriate to anonymise those decisions. But at the moment, and this is the key point, the only decisions that are published are those made on releasing those on an order for lifelong restriction. Now, there is, I believe, an appetite and an opportunity for more decisions to be published by the Pro Board, for more decisions to be in the public domain. Yeah.
It's a very similar intervention as I made earlier, and really just to find out whether he's had discussions with the Risk Management Authority in relation to how orders for lifelong restriction are dealt with.
I haven't. No.
You have?
I haven't. No. And that's all my amendments in this group.
Very much. I know that there is at least one member wanting to come in on Jamie Green's amendment, but I will bring in Sharon Dowie to speak to her amendment, and then I'll open it up to other members. So, Sharon Dowie to speak to Amendment 258 and other amendments in the group.
Thank you. My amendments 258 and 259 would safeguard victims by ensuring that where the Parole Board decides to refuse to release a discretionary life prisoner and there is a victim of their crimes, then the Board must provide a summary that explains why they have chosen to release them. This summary would then have to be provided to the victim or a family member if the victim is deceased. Those given life sentences will have committed very serious crimes, and we must ensure that victims or their families are notified when they're released and given a full account of the reasons behind this. Victims deserve transparency, and we have unfortunately seen in recent years that not all victims have been informed when their offender has been released from prison. This amendment will safeguard victims and ensure they and their families have transparency when it comes to the release of dangerous offenders.
Thank you very much. So do other members wish to come in? Fulton McGregor.
Thank you, Convener. And my apologies to you and colleagues on the committee, because I probably should have come in, and this is an intervention when the discussion was going on. So I just wanted to come in on the amendment around about remorse, and I know that we've had a good discussion on that, but I did just want to say to Jamie Green that my understanding as a previous criminal justice social worker is that remorse is an issue that's definitely taken into account in the probation system and generally in the criminal justice system as a whole. For example, at early stages of report writing through to when somebody is in custody and waiting any release. So that is something that I wanted to note. But I do agree with others. I don't think that we can support this amendment at this time. I think it raises a lot more questions than answers. Ronan Mackay's point about when people can't display remorse, you know, what impact might that have? And then, of course, the opposite, when people feign remorse. Now, you might be thinking, from what I said earlier, you know, that this is a system that people that are working in this is a issue that people that are working within the justice system grapple with every day. But I do agree with, I think it was Ronan Mackay, it might have been Pauline McNeill. I do agree that I think by bringing it into the bill, we run the risk of it becoming a crucial deciding factor one way or another. And I just don't think, as others have said, we've had the opportunity as a committee to scrutinise the full implications of that. So I would encourage the member, who I've got a lot of respect for. I think he's brought a lot to this stage of the bill and when he was previously on committee, but would encourage him not to press this amendment at this stage. I do apologise again, Convener. I think it would have been better in hindsight to have come in when the debate was going on there, but I felt that the member was getting a lot of interventions at that point as well. So, thanks.
Thank you very much. If no other... Katie Clark.
And I listened very carefully to what Jamie Green has said, but obviously we would want to know both what the Parole Board and the Risk Management Authority's position is, and to get a lot more information, I think, before really we should be enacting any amendments. In relation to Sharon Dowie's amendments, it would be interesting to hear what she thinks the status of the summary of reasons that she's proposing should be made would have, whether that's something that could be challenged. It is bringing, if you like, another document and another set of reasons into the process, and it would be useful to get more information as to how that would be treated and the status it would have, given the very complex nature of the decisions that are made by the Risk Management Authority on risk. So I don't know if that's something she could come back on now, or perhaps at a later stage before stage 3. It would be useful to get more information on that.
I think the amendments are brought in so that there's more transparency with victims and their families when people are released from prison. As Jamie Green had also said, there can be a cost implication in actually producing these reports. And as the Cabinet Secretary said in the earlier amendments that my colleague done, there is sometimes we don't need primary legislation. It can actually just maybe be a change in procedure or policy. And if we don't need legislation, then I'm quite happy if they can go and give more of this information to victims on the release. So it'd be interesting to see what the Cabinet Secretary says, to see whether we actually need legislation to get more information out to victims, or whether it's something that we maybe work on and bring back in at stage 3. And again, it was mentioned by Pauline McNeill earlier on, we didn't do any work with the Parole Board during this bill, so this is just the avenue that my colleagues managed to find to bring in all the amendments for the Parole Board, but it's not something that we actually looked at in great detail, which maybe we should have. Okay.
Okay, thank you very much. So, Cabinet Secretary.
Thanks very much, Convener. I very much understand how difficult and emotional it can be for victims and their families when the prisoner linked to their case comes up for parole and potential release. And I have met with a number of victims who have shared their experiences with me and how they feel the system can be improved to better support them through this part of the justice process. We all want to ensure that victims and their families are informed about how and why decisions are made, and to have an effective system in place for the release of prisoners, which keeps victims and their families informed and supported while maintaining the confidentiality and integrity of decisions and safety of all involved. The issues raised in this group, Convener, are deeply sensitive, so I will take my time to state my reasonings on my positions. Starting with Jamie Green's Amendment 249 and 250, I accept there is a strength in the sentiment expressed, but would urge Mr Green not to press these amendments and instead work with me in advance of stage 3 to develop some alternative drafting to ensure that the legal and operational aspects are fully considered. Amendment 249 intends that the Parole Board for Scotland must take into account the impact of its decisions on the safety and security of a victim and any of their family. The decision on whether to release a person on parole licence is of course a matter for Parole Board Scotland, which is independent of ministers. Victim safety and the safety of their family members is already taken into account under the consideration of public safety in existing rules, which mean the Parole Board must assess when a prisoner may be released without posing a risk to the community, including a risk to victims. Amendment 249 would be operationally challenging for the Parole Board to identify victims who are not signed up to the victim notification scheme. Amendment 250 would require that the prisoner governors must take the safety of the victim or victim family when considering whether to grant a prisoner a temporary release. Again, there are already clear directions in prison rules that instruct prison governors to assess the risk that the prisoner may pose a danger or cause harm to the public. The Scottish Minister's directions on the operation of temporary release reinforce the requirement that the Governor must assess whether the prisoner might cause harm to the public, and also that the Governor must also consider the view of victims where those views are known to them. So, as I said, there is a strength in the sentiment here, but we should consider the effect legally and otherwise in advance of stage 3, and I'm happy to do that. Convener, I acknowledge the important concerns that have motivated Jamie Green's amendments 256 and 257 and Sharon Dowie's 258 and 259, but I cannot support them today. The Parole Board operates with the primary aim of assessing whether an individual is suitable for release based on their readiness to reintegrate into society and the risk they may pose. The process is conducted carefully with all relevant evidence taken into account. While transparency is important, and it is important, there must be a balance to ensure that these decisions that will involve highly sensitive information are made independently based on thorough assessment given without fear or favour. It is also important to ensure that sensitive personal information about the offender, about victims and others involved in the case are not disclosed unnecessarily and unintentionally compromise their safety. The desire to ensure that victims and their families feel informed and supported is something that we all very much agree on. It is absolutely essential that those impacted by crime can engage with the process in a meaningful way, and we all want to ensure that they are treated with dignity and respect. However, I do not believe these changes require primary legislation and instead should be considered as part of the broader Parole Board Scotland rules. So I do fully intend to include consideration of this as part of the parole reform consultation, which I discussed as part of Group 13. And one of the reasons for that is some of the issues that Ms Clark touched on in and around the status of information. So I would ask Mr Green and Ms Dowie not to press these amendments and to allow the consultation to run to gather the widest possible range of views on the matter, and if they do, and if they don't, if they do press for committee to oppose. Moving on to Mr Green's amendment 251, 260 and 261. Again, whilst I recognise that these issues raised in these amendments are deeply sensitive and are an ongoing concern for the family of victims, and even with such emotive issues, we do also have to consider the practical and legal issues that arise. So, starting with Amendment 251, which would require the Parole Board must take into account any remorse shown by the prisoner in regard to the impact of their offence on any victim when deciding whether to grant parole. And I do understand that Jamie Green does not intend that this measure would require the prisoner to admit guilt where it had not previously been made through this expression of remorse in order to be granted parole. As he says clearly, this would raise other legal concerns. Convener, release on parole does not solely depend on the individual admitting guilt or showing remorse for their action. The board take into account all of the full circumstances of the case, including the offence itself, the trial judge report, as well as the individual's behaviour in prison. It can also examine whether they have taken any steps to address any underlying issues which may have contributed to their behaviour or that could inform their future actions. And, of course, Part 2, Section 11 of the 2022 Parole Board rules states that the Parole Board can take into account any matter that it considers relevant. So in this context, there is already scope for the Board to take account of the individual's overall actions and behaviour when considering release, which could, where applicable, include any expression of remorse or contrition. And in picking up on Ms Mackay's earlier points and Fulton McGregor, and I can say this with some certainty as somebody whose bread and butter was compiling parole reports, amongst other assessments, whether it was the old RE 124 or spousal assault risk assessments, that remorse, empathy is interwoven into the many assessments that social workers, prison officers, psychologists will make. But the difficulty is that, yes, about 80% of the prison population, we believe, have a communication difficulty, whether that's neurodivergence, learning disability, mental health issues. Therefore, where we need to take great care is with those who can learn the language of therapy, who can absorb the language of social workers and psychiatrists and psychologists, who can be very slick in communicating remorse, but what lies underneath that is a whole other matter and different motivations. It's also, to be blunt, it is not clear how the board would assess an individual's expression of remorse, given that ultimately the subjective nature of these matters and the difficulty of applying a consistent approach across different cases, of course. Yes.
Thank you. The slight conflict in this, though, is that in one hand, Cabinet Secretary, you said at the beginning of your comments that, of course, remorse is a factor that the board may take into account, but you've just listed exactly the problem, that you don't see how they can take it into account because of the subject nature of it. So either they do or they don't. I'm not quite sure which.
So I think what I'm clearly saying, Mr Green, is that in terms of work that is done with offenders to address their offending behaviour, that there is a very prominent strand in any assessment of someone's rehabilitation, their attitude to their offending history. And while some of us may have thought that we were very good at that work, I think we ultimately have to recognise the complexity of assessing people, and that, yes, the parole board, because of the way in which the rules are drafted, have no doubts can and do take this into account. I suppose where I have concern is that I think the practical effect of your amendment is, at one level, won't have the impact that I think you're striving for, but this is the amendment that causes me most anxiety, because at the end of the day, this is ultimately subjective, particularly where I wouldn't want to be tilting the system in favour of our more socially adept, slick communicating, more deviant offenders. And yes, of course, assessments can take account of someone's neurodiversity and all the rest of it, but I just genuinely think, as someone who's worked in the field, that this is a deeply problematic area. And in this group, it's 251 that causes me most concern. So to summarise, I hope, on this amendment, Convener, given the capacity that the Parole Board has to address this concern where it arises, I don't support this amendment, and I would ask Mr Green not to press it, and if he does, for committee to oppose. Yes, please. Okay.
Just for my own clarity, thanks, Cabinet Secretary. So, effectively, at least part of your case is that Amendment 251 is not necessary because the Parole Board's already doing it, and so there's no need to reiterate it, such that if we don't, if Mr Green chooses not to press, or he does, but the committee votes it down, that actually the remorse piece will still be in there because it's there already. Is that a fair reflection?
So remorse and empathy is there, but it's in the context of everything else to enable that rounder, more holistic view of risk. If I can move on to Amendment 260. Convener, I am very aware of the deep hurt that this issue can cause to a victim's families and friends. And while it should be noted that the failure to disclose the location of a body can already be prosecuted as a criminal offence in itself, that of attempting to defeat the ends of justice, the court can and will take this into account. An offender's refusal to disclose the location of a victim's remains when sentencing. It is, of course, I'm aware, one of the many issues that Mr Green did consult on in his proposition for a victims' bill. I also remember very well the debate that Mr Green and I had at stage 3 of the Bail and Release Bill, now Act, and at that time I raised a number of legal issues with his then proposition, because it was a much more sweeping amendment that certainly would have caused great anxiety in terms of ECHR, for example. And it is a matter that, since that debate, I have given considerable thought to, and if I recall correctly in that debate, I did say to Mr Green that my door was open on these matters. I should add, Convener, that the Parole Board already does take such matters into account when considering release. The Parole Board rules were amended in April 22 to make clear that failure to reveal a victim's remains is a matter that the Board may take into account when making their decision where it is applicable. In those cases where such circumstances might arise, it is clear to see that the Board does have scope to reflect this concern in their considerations. However, I have no issue with this amendment, which would require the Parole Board, when considering the release of a prisoner sentenced for murder or culpable homicide, to take account of whether the prisoner has information about the disposal of the victim's remains but has not disclosed it. And I am happy to support this amendment. It may be that we propose some tweaks to the drafting at stage 3. This may be needed to ensure a good fit with other stage 3 amendments, particularly the other amendments in this group that we propose to work on with Mr Green before we get to stage 3. So some minor changes may be needed, but I'm happy to support Amendment 260 for now. I cannot, however, support Mr Green's Amendment 261, which addresses a similar issue, requiring that whether a prisoner serving a sentence for murder or culpable homicide should be granted temporary release, and when the Governor has reasonable grounds to believe that the prisoner has information about the victim's remains but have not disclosed it, then they must take the issue into account when making that decision. The grant of temporary release is only made after careful consideration, and any failure to comply with the conditions of release can result in recall to custody. Temporary release can cover a broad range of activities, from escorted day release and, where appropriate, to periods of home leave. It can also be utilised for prisoners to be escorted to attend medical treatment or to events such as a funeral of a close family member. Again, I appreciate that when a victim's family are left without the knowledge that they seek, that such circumstances may be difficult to accept. but the operation of temporary release is an essential part of the process by which the Scottish Prison Service can assess the individual's readiness for eventual release, and it provides robust evidence upon which the Parole Board can base its decisions. The Scottish Prison Service conduct a case-by-case assessment before each grant of temporary release, including consideration of the risk of whether the prisoner may pose a danger or cause harm to the public. Any temporary release is made under detailed licence conditions, which can be adjusted to reflect the particular circumstance in each case. In addition, Scottish Ministers' directions on the application of prison rules in regard to the use of temporary release do require that the Governor must consider the views of victims when deciding whether to grant temporary release, where their views are made known to them. This can be accommodated through the work of the Victim Notification Scheme, and where the victims' families are registered to VNS, they will have the opportunity to make representations to the SPS before a prisoner is permitted temporary release for the first time. Given that there is a broad assessment made before any use of temporary release, and there is already scope for victims to express their concerns regarding the possibility of temporary release being granted, it would not be necessary to add the specific measures proposed in this amendment. In light of this, I cannot support the amendment and urge committee to oppose it. Thank you, Convener.
Thank you very much, Cabinet Secretary. So, Jamie Green to wind up and press or withdraw Amendment 249.
Thank you. I think that's been a really good debate. I know it's taken some time, but it was very important. And can I thank members for their contributions as well. I think it's raised some really important issues around the parole process, around the decision-making that goes on in parole hearings and victims' understanding of those decisions and the levels of communication that they're entitled to and are receiving or not receiving, as the case may be. And I think it's been really important to put some of that out in the public domain. I'm really pleased on a number of counts, particularly the Cabinet Secretary around Amendments 249 and 250, which I think at the outset I said for me was the most important in this group. And that's this getting on the face of legislation that the consideration of victims' safety and security is paramount throughout the parole process. And if the Cabinet Secretary, as I think she alluded to, is willing to work with me ahead of Stage 3 on something in this vein, I will happily do so, and I would very much like to see that come back. Although I take on board comments made about some of the other amendments around it, with which there were some problems. The amendments 256 and 257 around the parole board more generally, again, maybe things that do not require primary legislation, but may feature as part of any future consultation. I'm really pleased to hear actually the government is about to undertake a much wider and more comprehensive look at parole more widely. I think that's something that's been called for quite some time. I really look forward to seeing that piece of work when it's announced, when it comes out in August, the subsequent responses to it and any legislative changes that arise from it, be they secondary legislation or otherwise. And I know that the committee will do them justice. And if I can play my part meaningfully in any of that, please let me know. I think that's a really important step and probably a good way of looking at all this holistically. Because I think some of my amendments in this group and the last group were in their own right quite piecemeal in making tweaks and reforms to the process, but important ones I felt. I think if they can form part of wider changes to parole board rules, and we actually see those rules change, and that's the Cabinet Secretary knows that's something that I will hold the government to account on in due course. So I think that's all very positive. On 251, this issue about expression of remorse, I'm not going to revisit the arguments. I think it's been a good discussion actually, and I appreciate the language used around some of this is very complex. It's very hard to define remorse. How do you demonstrate that you're sorry for something without just saying I'm sorry? You know, I do appreciate the complexity to that, but I didn't make this amendment up for the fun of it, and I pay particular tribute to Ellie Wilson, who's been calling for an amendment of this nature. Perhaps even, as I said, some people are asking to go a lot further with this belief that if you don't show remorse, you should stay in prison, is effectively what some people think. But again, I tried to find a compromise on this as best I could, and this idea that it should be a factor, and it should be on the face of a bill that remorse is a factor, when it comes to a release decision, I felt was an important attempt to at least try and put it into this bill, but I can see that will be a futile attempt. I'd be interested to hear after this session what those campaigners, how they respond to the debate that we've had today and whether they feel there is some room for something ahead of stage 3. But I'll leave that to them to consider, and I'll happily work with anyone who approaches me in that regard ahead of stage 3. But for now, I won't push Amendment 251, I think for all the good reasons that have been given. And finally, can I just put on record my thanks to the Cabinet Secretary for accepting Amendment 260, which again I dubbed in my consultation and today the Suzanne's Law element of my own proposition. I think it's a really important one. It's something we've debated as a Parliament over many years. The former Justice Secretary, Mr Yousaf, promised to look at this and I think tried to tweak the system as best he could. The Cabinet Secretary and I had a good exchange on this a few years back as well. And I've kept it live and I've kept it on the table for good reason. And I think the amendment today that, again, I felt was a compromise, a more legally sound compromise, met the needs of those who are asking. It may not keep everyone happy, I understand, but I've certainly tried my best to get it on the statute books, and I'm very pleased that hopefully we'll do that this afternoon. And again, I'm happy to tweak it ahead of stage 3 if it makes it more legally sound. So with that, I'm very grateful for the debate we've had in the comments, and indeed the support that the government's offered for some of my proposals this morning in general. So thank you.
Okay. So can I just confirm if you wish to press or withdraw Amendment 249?
Withdraw.
Thank you. So the member has indicated that they wish to withdraw the amendment. Does the committee have any objections? Okay, thank you very much. So I call Amendment 250 in the name of Jamie Green, already debated with Amendment 249. Jamie Green, to move or not move?
Not moved.
I call Amendment 251 in the name of Jamie Green, already debated with Amendment 249. Jamie Green, to move or not move?
Not moved.
I call Amendment 252 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
If it's helpful, I'm not moving any amendments up until... but you have to do them individually, do you? Okay.
If you don't mind, I'll go through it to keep myself right.
No problem, not moved.
Thank you. Okay, so that was a not moved on that one. Thank you. So I call Amendment 253 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
Not moved.
I call Amendment 254 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
Not moved.
I call Amendment 255 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
Not moved.
Okay. Call Amendment 256 in the name of Jamie Green, already debated with Amendment 249. Jamie Green, to move or not move?
Not moved.
I call Amendment 257 in the name of Jamie Green, already debated with Amendment 249. Jamie Green, to move or not move?
Not moved.
I call Amendment 258 in the name of Sharon Dowie, already debated with Amendment 249. Sharon Dowie, to move or not move?
I've noted the Cabinet Secretary's comments that it doesn't require primary legislation and the consultation will be commencing in August, so I'll not be moving.
Okay. So I call Amendment 259 in the name of Sharon Dowie, already debated with Amendment 249. Sharon Dowie, to move or not move?
Not moved.
I call Amendment 260 in the name of Jamie Green, already debated with Amendment 249. Jamie Green, to move or not move?
Moved.
Okay. So the question is that Amendment 260 be agreed to. Are we all agreed?
Yes.
Are we all agreed? Yes. Okay. Thank you. So I call Amendment 261 in the name of Jamie Green, already debated with Amendment 249. Jamie Green, to move or not move?
Not moved, Convener.
And I call Amendment 262 in the name of Jamie Green, already debated with Amendment 246. Jamie Green, to move or not move?
Not moved.
Okay, thank you very much. So we now move on to the next group, which is special measures in civil cases. And I call Amendment 141 in the name of the Cabinet Secretary, grouped with amendments as shown in the groupings. Cabinet Secretary to move Amendment 141 and speak to all amendments in the group.
Thank you, Convener. Let me start with my own amendments 141 to 144. The current bill deems a person vulnerable in a civil case if they have a civil protection order against another party to the case. Amendment 141 adds law boroughs to the list of relevant orders. This is an order which can be made to protect against violence by a particular person. The amendment makes it clear that interim remedies and measures are included. It is, for example, common for a person to obtain an interim interdict. In addition, Amendment 141 provides that a person is to be deemed vulnerable if they are applying for a civil protection order or have brought an action for damages following sexual abuse, harassment or assault. Amendment 143 amends Section 15 of the Vulnerable Witnesses Scotland Act 2004. Section 15 makes provision on vulnerable witnesses and on taking the views of a vulnerable child witness into account in relation to special measures. As Section 15 stands, it includes a presumption that a child aged 12 or older is of sufficient age and maturity to form a view. The amendment replaces this presumption with a new one that the child is able to express their views unless the contrary is shown. Amendment 142 is a related technical amendment. Amendment 144 amends Section 33, which makes provision on special measures and non-evidential hearings. It relates to where a party to the case has not been deemed vulnerable, but the court considers that the party may nevertheless benefit from special measures. This amendment provides that when making an order in these circumstances, the court must take into account of the party's views and, if the party is a child, the views of the child's parent. It also provides that the court must have regard to the best interests of the party. Let me now turn to Liam Kerr's amendments. I am pleased to be able to support 122, 124, 126, 127 and 128, but I cannot support 123 and 125. I do not want to speak for Mr Kerr on his amendments, but I would note that the Scottish Government consulted in 2021 on the planned register of solicitors as provided for under the Children's Scotland Act 2020 for certain family proceedings. This bill will extend the 2020 Act provisions to civil cases more generally. I am happy that amendments 122 and 124 would require Scottish ministers to set down in regulations the level of remuneration for solicitors on the register as opposed to the current position of this being optional. I can also support amendments 126 and 127, which will require the Scottish ministers to prepare and publish a report on the consultation that we need to have with the Faculty of Advocates and the Law Society of Scotland before making regulations on the register. I also support Amendment 128, which sets down some details of what the report should cover. However, I cannot support Amendments 123 and 125 as they would not be workable. Amendment 123 requires that Scottish ministers must confer duty of maintaining the register on a person as opposed to this being an option under the bill. Our intention at the moment is that the duty to maintain the register will remain with Scottish ministers, with the day-to-day administration to be carried out by a contractor. It would not therefore be appropriate for this to be a requirement to confer the duty of maintaining the register on another person. Both the Scottish Legal Aid Board and the Scottish Courts and Tribunal Service have told us they do not want this duty, and I don't want to confer or perhaps foist this duty on a body which does not want it. And I think it better to proceed as we proposed. Therefore, I ask committee to oppose amendments 123 and 125 if pressed, and to support the remaining amendments in this group. And I move amendment 141. Thank you, Convener.
Thank you very much. So, Liam Kerr to speak to Amendment 122 and other amendments in the group.
I'm very grateful, Convener, and I'm grateful to the Cabinet Secretary for her remarks just now. For the benefit of the committee, I have 7 amendments in this group, numbered 122 to 128, and all relate to Section 32 on page 16 of the bill. Section 32, as drafted, looks to amend the Vulnerable Witnesses Scotland Act 2004. And subsection 4, as drafted, ensures that as Section 22D of the Vulnerable Witnesses Act sets up a presumption that the personal conduct of certain cases should be prohibited, a register of solicitors who may be appointed by a court in such circumstances should be maintained. Obviously, for full transparency here, I remind my colleagues that I am a practising solicitor for what follows. The section goes on at subsection 2 that the Scottish ministers must, by regulations, specify the requirements the person must satisfy to be on and stay on the register. And regulations must then set out process for entry to, removal from and appeal on a decision about the register. And it's important to note that no members have raised any concerns with these clauses. However, by the omission of remuneration in this regulation obligation, Scottish ministers do have the discretion to regulate about the remuneration of solicitors appointed in these cases, but they do not need to do so. Accordingly, my Amendment 122 looks to fill that lacuna in the legislation and require the Scottish ministers to address this aspect in those regulations. Amendment 123, which I shall come back to, simply takes the principle on and ensures that ministers are obliged to confer a duty to maintain the register on someone. Amendments 124 and 125 are consequential to these. Then Amendments 127 and 128 relate to the same set of amendments being made to the Vulnerable Witnesses Act. The new Section 22E, subsection 3, requires that before the regulations that we've just looked at are made, under Section 22E, subsection 2, Scottish ministers must consult with the Faculty of Advocates and the Law Society. Again, no member, and to the best of my knowledge, no stakeholders have raised any issue with this perfectly supportable principle. But it occurred to me that that's all well and good to have consultation, but it's important to know what it is finding, what it finds and what it concludes. And so my Amendment 127 simply requires a report on that consultation to be published, while Amendment 128 sets out what should be in it. That ensures that the Society and the faculty's views are able to be fully considered before making regulations that could affect access to the legal professions that involve vulnerable people. For clarity, the Amendment 126 is simply a technical change to pave the way for 127 and 128 to be inserted properly. The Cabinet Secretary made some important remarks, however, about Amendment 123 and 125. I can see, on reflection, that my Amendment 123 would override the new 22ED1, or I, which, as drafted in the bill, leaves the decision with the Scottish Government, the regulation with the Scottish Government, and the Scottish Government may then put the responsibility out. My Amendment 123 would mean that the Scottish Government must put that out. Whether or not that is the best idea, that wouldn't be particularly sensible in my view, and that would certainly not be my intention. And I have also listened to the Cabinet Secretary's reflections on the agencies that would be involved and their opinion on it. So with that in mind, Convener, it wouldn't be my intention to press Amendment 123 or Amendment 125 when I'm asked that question. The rest of them I do intend to move.
Thank you very much. Would any other members like to come in? If not, Cabinet Secretary to wind up.
I have nothing further to add, Convener, if that's all right.
Okay, thank you. So the question is that Amendment 141 be agreed. Are we all agreed?
Yes.
Are we all agreed? Can I just confirm with Ms McNeill and Ms Clark? We agreed. Thank you. Okay, so the question is that Section 30 be agreed to. Are we all agreed?
Agreed.
Okay. The question is that Section 31 be agreed to. Are we all agreed?
Agreed.
Okay. I call Amendment 122 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr, to move or not move?
Moved, please.
Okay. So the question is that Amendment 122 be agreed. Are we all agreed?
Yes.
Yeah. Thank you. I call Amendment 123 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr to move or not move?
Not moved.
Thank you. I call Amendment 124 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr to move or not move?
Moved.
Okay. So the question is that Amendment 124 be agreed to. Are we all agreed? Yes. Thank you. I call Amendment 125 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr to move or not move?
Not moved.
Okay. I call Amendment 126 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr to move or not move?
Move.
Thank you. So the question is that Amendment 126 be agreed to. Are we all agreed? Yes. Thank you. I call Amendment 127 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr to move or not move?
Move.
Thank you. The question is that Amendment 127 be agreed to. Are we all agreed? Yes. Thank you. And I call Amendment 128 in the name of Liam Kerr, already debated with Amendment 141. Liam Kerr to move or not move?
Move.
The question is that Amendment 128 be agreed to. Are we all agreed? Yes. Thank you. And the question is that Section 32 be agreed to. Are we all agreed?
Agreed.
Thank you. I call Amendments 142, 142, 143 and 144, all in the name of the Cabinet Secretary and all previously debated with Amendment 141. And I invite the Cabinet Secretary to move Amendments 142 to 144 on block.
Moved on block.
Okay. So does any member object to a single question being put on Amendments 142 to 144? No? Okay, thank you. So the question is that Amendments 142 to 144 are agreed to. Are we all agreed?
Agreed.
Thank you. And the question is that Section 33 be agreed to. Are we all agreed?
Agreed.
Thank you. Okay, thank you. So we now move to the next group, which is trial diets. And I call Amendment 91 in the name of Sharon Dowie in a group on its own. Sharon Dowie to move and speak to Amendment 91.
Thank you. My Amendment 91 would require the Scottish Courts and Tribunal Service to prepare and publish an annual report to Parliament on the use of floating trial diets and the impact they have on victims. My amendment tries to find a common-sense compromise between two arguments, balancing the traumatic experiences of victims with the unfortunate reality that our courts are overstretched and backlogged. We've heard from victims that floating trials can add to the trauma and stress that they face. As one victim of sexual crime told the committee, floating trials are not very good because you're having to remember 10 or 11 dates that will always be significant to you. Dates are massive for people suffering with post-traumatic stress disorder and complex post-traumatic stress disorder. Rape Crisis Scotland highlighted that floating trial diets can have an impact on the quality of evidence that victims are able to give. Chief Executive Sandy Brindley said, people have a trial that is allocated to a certain period, and every night they are waiting on a call to tell them whether it is going to go ahead the next day. That is far from trauma-informed practice, and it is not how we get the best evidence from vulnerable witnesses. Sandy Brindley also told us how some victims end up having to rehearse their evidence every day, waking up and going through it all in their mind just in case they're called to give evidence. The traumatising effect that this could have on victims is deeply concerning. The Lord Advocate shared with us her experience of prosecuting sexual cases in the High Court and the trauma that is inflicted on victims by making them wait by the phone to find out when they will be called to give evidence. The Lord Advocate called floating trial diets a profound problem and explained that they are deeply upsetting for victims who are waiting for their case to be heard and challenging for the prosecutor who is waiting for the case to come in. However, We have also heard from the Scottish Courts and Tribunal Service, who estimated that moving entirely from floating trials to fixed trials in the High Court would add an average of at least 11 weeks of delay to each individual case and worsen the court backlog. We know that this government has presided over an extreme backlog in the courts, and the Courts and Tribunal Service make the point that floating trial diets allow for better flexibility in scheduling cases and in using the finite resources that are available to them. Victim Support Scotland, in their evidence, acknowledged there is unfortunately a trade-off between certainty for victims and the impact in courts. But when they've spoken to victims, they've said that they prefer certainty about the date of their trial, even if it does mean a delay. I know that the Cabinet Secretary has heard both arguments and supports reducing the use of floating trial diets because of the anxiety and uncertainty they can cause to victims, while also recognising that the state of the court system means abolishing them may do more harm than good. That is also the position of this committee, who have concluded that it is unfortunately not realistic to stop the use of floating trials completely at this time. However, given the impact on victims, it would be wrong to simply do nothing in the face of the testimony we've heard. That is why my amendment would provide for an evidence-led approach to ensure that the proper research has been conducted before we take any further action on changing the use of floating trial diets. There is no reason not to do this. If we want to reduce or phase out floating trial diets, we need to know exactly when they are used, how they are used, their impact on victims, but also how we can balance this against the practical realities that abolishing them would have in the courts. I hope the Cabinet Secretary and members of the committee will support my amendment, which is a sensible compromise, allows for an evidence-led approach to this difficult issue, and would be a first step towards reducing floating trial diets and ultimately helping victims, which we all want to see.
Okay, thank you very much. Does any other member wish to come in? No. Rhona Mackay.
Thanks, Convener. I completely agree with what what Sharon Dow is saying, except you've laid out the case, the situation really well, and I think we know what the situation is. So I'm not sure that I think this amendment is necessary, because you've stated the effects of not doing it and the harm that they do, and the courts are aware of that. So I'm just in the position that I don't think this is a necessary amendment.
I think it's one where we heard from a lot of the witnesses that came before us about the trauma. We've heard from the Cabinet Secretary knows about the trauma, the Lord Advocate, everybody knows the trauma that it causes, and it's something that the bill is there to go and address the trauma that victims are facing when they go through the court system, and it's actually the only amendment in the block, so I don't feel as if as a committee we had done anything to go and address that trauma that the victims were facing. So if there are any other things that we can go and do that the members would have suggestions on that would improve the situation for victims, I would be happy to hear them, but I think this is maybe a first step of looking at the full situation, getting a report back to see when are they used, why are they used, what are the impact on victims, and what can we actually go and do to go and improve things for victims, because this is what the bill's meant to do, and we're supposed to, well, I hope we're passing legislation that will improve things for victims rather than just sound good, and that's one of the things that, for me, when we listen to victims giving their testimonies, that was another area that we really needed to look at to go and see how we could improve it.
Okay, thank you very much. If no other members wish to come in, Cabinet Secretary.
Thank you, Convener. I very much understand the intention behind Amendment 91. The committee has heard from victim support organisations and from survivors themselves about the distress that the uncertainty of floating trials can cause, and indeed it was an issue that was explored in the policy memorandum for the bill. You have also heard from the Scottish Courts and Tribunal Service that abolishing floating trials in the High Court would add, on average, 22 weeks to reaching a trial date. And this was reflected in the Committee's Stage 1 report, which stated, "We do not think it is realistic to legislate to prohibit the use of floating trials completely. Instead, we recommend that the Scottish Courts and Tribunal Service should make every effort to keep the use of floating trials to the absolute minimum that is required. And I agree with this position, and I would like to see the use of floating trials reduced, but not at the expense of people needing to wait for justice. The court service also recognises that there is a need for greater transparency and awareness over the use of floating trials, and I understand that they are considering ways that they could provide more information on that. Might be worth also being aware that both the Scottish Courts and Tribunal Service and the Crown Office are trying to improve estimates about how long trials will run for. 2 years ago, around 50% of cases lasted longer than anticipated, and that has now reduced to 33%. It's also worth highlighting that the bill already requires the courts to consider trauma-informed practice when business is being scheduled, and in the new Sexual Offences Court there will be a presumption that complainants pre-record their evidence before the trial, helping to reduce the direct impact that a distant or uncertain trial date has on them. I do understand Ms Dowie's desire for greater accountability over how floating trials are used and for more to be done to recognise the negative impacts that they can have. However, I don't believe the amendment would give us meaningful information. The reasons for that is that the amendment would only capture floating trials in the High Court, not solemn trials in the Sheriff Court, which actually account for a greater number of trials without a fixed start date. More importantly, though, it would require the court service to report every year on the impact that floating trials have on victims. But the court service has very little direct engagement with victims and so could not report in a way that gives us any real insight into victims' experiences, and therefore I urge the committee to oppose the amendment.
Much. So Sharon Dowie to wind up and press or withdraw Amendment 91.
Thank you. I would agree that yearly reporting might be a bit onerous on the system if it's not going to provide any real impact, but I would ask that it's kept high on the agenda of the Cabinet Secretary so that when she's talking to various officials in the justice system, if she can make sure it's high on the list of trying to find a solution, but I won't be moving it.
Okay, thank you very much. So the members indicated they wish to withdraw the amendment. Does the committee have any objections? Okay, thank you very much. So we now move to the final group for this morning, which is court transcripts. And I call Amendment 145 in the name of Pauline McNeill, grouped with Amendments 179 and 263. Pauline McNeill to move Amendment 145 and speak to all amendments in the group.
Thank you, Convener. I speak to Amendment 145 in my name, which is a probing amendment. This amendment makes the government-led pilot for access to free court transcripts become permanent. All members will be aware that Hannah Stakes, who is a campaigner on this issue, says that there have been 84 applications to date, and she's been contacted numerous times by those who have applied, articulating of the importance of this to them personally. Eamon Keane, solicitor who acts for victims of sexual violence, said, "In my view, the free pilot has aided my work greatly. The transcript of evidence is often the only comprehensive and objective account of what was or was not said in cross-examination in a case." And he goes on to say that clients understandably only have a partial memory of the process of giving evidence. I think quite a critical point. I can think of 2 cases where without the transcript matters would have dragged on to everyone's detriment, he went on to say. Angela Constance, Cabinet Secretary for Justice, has said that most of the applications have been made in relation to seeking some degree of closure, recovery, in keeping with the emphasis on trauma and informed person-centred aspect of the pilot. I would like to put on record how much I welcome the Cabinet Secretary's extension of this important pilot. I know she's committed to this, but I just wanted to probe the issue, ensuring that we had it on the record that I would want to see this as a permanent measure, but I accept it needs to be tried and tested. Thank you.
Okay. Thank you very much. So I will now speak to Amendment 179 in my name. I'm likewise very pleased to join colleagues to speak on the issue of access to court transcripts for survivors of rape and serious sexual offences. And I want to thank the Cabinet Secretary for the very positive way that she's engaged with both myself and other members of the committee on this issue. The difficulties that survivors have historically had in accessing a record of a trial, it was first brought to the committee's attention in 2021, and I pay tribute to the women who described the challenges they faced, with one having to pay over £3,000 for a transcript. For some survivors, access to transcripts has a practical function where they may be involved in another process, such as a complaint about their treatment. For many, access to a record of what was said is an important part of the healing process and importantly reflects a justice system that is trauma-informed. And as one survivor told us, and I quote, "If people are unable to afford transcripts to corroborate complaints against those in the legal profession, then it essentially means lawyers are unaccountable. This should be of grave concern to a democratic society." So my amendment is also a probing one and is relatively narrow in its scope, relating only to sexual offences that are set out in section 288C of the Criminal Procedure Scotland Act of 1995 and which are currently included in the ongoing pilot. The amendment does, however, relate to cases heard in both the High Court and the proposed new Sexual Offences Court. So I'm very grateful to the Cabinet Secretary for her ongoing support and willingness to extend the pilot, and I'm also grateful to her for indicating to me her position on seeking to take some time to consider issues of potential such as a potential legislative change and, of course, the costs involved. And I'm also grateful for her work or her invitation to work with her to discuss what may be developed ahead of stage 3. So I therefore will not press my amendment, and I thank the Cabinet Secretary for her engagement on this matter, and I look forward to working with her further on this issue. Thank you. So, Jamie Green to speak to Amendment 263 and other amendments in the group.
Thank you, Convener. Can I thank colleagues? It's interesting you've got three MSPs from different political parties all on the same school of thought about access to court transcripts. I think that's really positive, and it's good to see the convener of the committee in this regard as well. The last two speakers have said their amendments were probing amendments. Mine isn't. Mine is a substantive amendment that I hope the government will give some thought to. The reason for that is because I've listened to the arguments over the years about access to court transcripts. We've all heard the same evidence on this. We've all heard the same points of view expressed about how ridiculously expensive and difficult it is. And I think actually as a result of those conversations, many of which happened a number of years ago, there was an element of pressure, I think, from both within and outside of Parliament for the government to do something about it. I think the pilot that was specifically in relation to victims of rape and sexual offence cases being able to access transcripts was a very welcome one. I think the extension of that pilot is also welcome. I understand that these things come at a cost, both monetary and also resource-wise as well. But I've gone about this a slightly different way with Amendment 263. Instead, I understand it would be probably quite impractical, unfeasible and probably quite expensive to make all court transcripts accessible and free to all people all of the time. Now, I'd like to think we can get to a position where that's possible in the future. I don't really understand why it isn't currently the case in the digital age. Put it this way, we've been here for 3 hours and 4 minutes so far this morning, and every single word that's been said in this committee, verbatim, will be made available to the public within 24 hours for people to scrutinise and interrogate. Indeed, form the future content of my riveting memoirs, which no doubt I'll publish. But that's the point, is that it's possible and doable in the modern landscape to make what is said in public available to the public when they so need it. And that's what's really key about the argument about court transcripts, is these can offer a vital piece of resource to victims as they go about future interactions with the justice system. So my amendment will establish, if it's accepted, a permanent fund that will allow people to access court transcripts. So I appreciate that the action of producing these transcripts comes at a cost. I'm hoping that cost will come down, but we are where we are. In the meantime, instead, I've created almost a sort of parallel legal aid system that will allow people to apply for access to the fund in order to subsequently pay for the court transcripts. I think this would be a more permanent solution than simply having an endless trial after trial of free transcript access without any long-term solution. I believe we could amend the Criminal Procedure Scotland 1995 Act that would create a permanent access to transcripts via a dedicated fund for this purpose, and this purpose alone. Now, my amendment actually allows the Scottish Government, perhaps through secondary legislation or regulation-making powers, and I'm willing to look at that, in terms of how the applications are made, the eligibility criteria, the process for doing so, and in coming up with this process, that the ministers must consult with relevant people, and it's all the people you'd expect them to consult with. Again, I think the pilot scheme is a short-term fix to a long-term problem, and whilst the government's willingness to do that is welcome, I note from the letter that was sent just 2 days ago to the 3 members who have an amendment of this nature, is that the Cabinet Secretary, you say that I do think further thought is required how we deliver a principle of free access in a way that is deliverable, sustainable, fair and cost effective. And I don't disagree with that. But when I sat just over there about 3 years ago, we had this conversation. There's been plenty of time to come up with further thought as to how we deliver this in the long term. And I've tried to come up with a practical solution to that further thought. I also believe it should be made more widely available and not just restricted to rape and sexual offence cases, which is why I believe that approaching this in a slightly different way, by creating a fund that has set criteria about who can apply which cases, for example, we are therefore able to open that out outside of the scope of rape and sexual offences. Because there may be other cases where people require access to transcripts. It may be domestic abuse cases. There may be a whole wide range of factors that I would like to extend the franchise to. And therefore, by looking at it in a slightly different way, by accepting there's not an unlimited pot of cash to do that, but putting aside some money to do it, and putting down the ground rules about who can apply, I think people will understand that there is still some fairness and rationale, a reasonable approach to that. And I hope that's something that the Cabinet Secretary will reflect on. But I think it's good to see members addressing this issue and trying to get something in the face of the bill. If it's something we can all bring back and work together on at stage 3, I'm very happy to form part of that discussion. And hopefully we can get something in this legislation at stage 3.
Thank you very much. Does any other member wish to come in? Okay, thank you. Cabinet Secretary.
Thank you, Convener, and let me start by assuring members that I view all 3 amendments with the same seriousness, and I have endeavoured to keep committee informed of progress with the current pilot, which is enabling access to free court transcripts for victims in rape and serious sexual assault cases, and this is the first such pilot within the UK and is attracting interest from others. I have been very open with the committee about the challenges, most particularly regarding the level of demand, the need to meet our obligations under data protection law and the current limitations of technology redaction or artificial intelligence, particularly in terms of accuracy. And I do recognise that there will be an opportunity in the future and an area to be considered as part of the current pilot extension. In addition, I remain mindful of concerns expressed about how that might see a change in behaviour and transcripts being shared through social media and if that would be a concern, I am therefore ever conscious of ensuring that we consider any unintended consequences of our actions and to be confident in how we might respond if that concern was realised. However, the evidence to date does not support that concern, but of course the pilot is still in relative infancy. I've also been reassured by the detail provided by the applicants that the reasons behind requests for transcripts accords with the Scottish Government's wider aims to deliver a truly person-centred, trauma-informed justice system. Some of the feedback also suggests more needs to be done, and this is why I've extended the pilot for a further 12 months so that we can resolve any issues ahead of assessing what changes may be required in legislation. And it is worth reiterating that I want the pilot to provide information which will support any future legislative change to the general position under the Criminal Procedure Scotland Act 1995, which is where the 3 amendments in this group are founded, and the specific secondary legislation, the transcript of Criminal Proceedings Scotland Order 1993 and the transcripts of Criminal Proceedings Scotland Amendment Order 1995, all of course pre-devolution legislation. I have already outlined to the 3 members with these amendments that whilst I do not support them as they currently are, I am entirely sympathetic to their aims and want to work with them all ahead of stage 3, as there is an opportunity to include aspects of all their intentions at that point. Pauline McNeill's Amendment 145 would significantly increase the number of free transcripts being produced and place a major capacity issue on the Scottish Courts and Tribunal Service and the company that has been procured for this purpose. This in turn would have a significant cost to the public purse. However, I would like to discuss with Ms McNeill further alongside Jamie Green's Amendment 263. This is an innovative proposal which recognises the costs associated with the concept of free transcripts, which of course come from the public purse. And I would therefore like to consider in longer time than we have had the amendments, what the proposal around a regulation power which Jamie Green's amendment introduces, what that would look like in practice and how it could have the effect of enabling the wider access aspiration outlined in Amendment 145 from Pauline McNeill. Turning to Amendment 179 from Audrey Nicholl, and notwithstanding my words of caution expressed before, I do consider that there is an opportunity to build on the premise of the amendment subject to some further refinement. I fully understand the desire to ensure certainty around the pilot and the limited opportunity remaining to achieve that in this parliamentary term, and I also would like to place the current pilot on a statutory footing. I would note that it is important that we get this right and that we recognise that there may also be a need for further legislative changes in the future, informed and evidence from a range of areas, including from those who have participated in the pilot to date. And I think that delivers a level of cross-party consensus and therefore recognition of how we can deliver and acknowledge our respective positions. Therefore, noting that I will work with members on how we can deliver and acknowledge our respective positions, I ask the 3 members to withdraw their amendments and work with me and work collectively ahead of stage 3.
Okay, thank you very much indeed. So, Pauline McNeill to wind up and press or withdraw Amendment 145.
Thank you very much. I'm sure I speak for all the members who have spoken in this. I'm delighted by the Cabinet Secretary's response, and it's what I expected because I know that you're personally committed to this. And I agree that I think we have to be clear about what the purpose of the transcript is in the first place, because one of the points I spoke to, which could be helpful to lawyers as well as to victims, so it's worth scrutinising that in some detail, who it should be extended to, and obviously cost. The critical thing is to make it permanent. It must be sustainable in the long run, or it's not worth doing. So I'm content to not move it or seek withdrawal from the committee, and delighted to work with the Cabinet Secretary in any way to get something in stage 3 that everybody would be content with. Thank you.
Thank you very much. So the members indicated they wish to withdraw the amendment. Does the committee have any objections?
No.
No? Okay, thank you very much. So, I call Amendment 179 in my name, already debated with Amendment 145, and I can confirm that I will not move the amendment. And I call Amendment 263 in the name of Jamie Green, already debated with Amendment 145. Jamie Green, to move or not move?
On the basis of what we've heard, not moved.
Okay, thank you very much. Okay, so I'm going to pause our stage 2 proceedings at this point. Our next group is a significant and substantial group that I do not intend starting at this point today. So we will resume consideration of more amendments at our next meeting on Wednesday, the 26th of March. So can I thank the Cabinet Secretary and all her officials for attending this morning, and I close the meeting. Thank you very much. Thank you.